Oh, there he is.
Good morning.
And in this one, what is plaintiff's claim?
Your Honor, the current balance, including costs, is $1,994, 1994.
All right. And sir, how are you intending on getting that paid?
I recently started a new job. I hope to reclaim this and get on top of it within the next month or so.
All right. So if I adjourn this out a week, how much do you think you can pay toward this?
I get paid next week. I should be able to put at least $500 to $600 towards it. I get paid in another 2 weeks. Then we're going to catch up on the next month. It's really tough to level. I work landscaping. We do have downtime. I'm confident I can make this up within the next 2 months and stay on top of it. But it's hard for me.
Here's what I'm going to tell you. Here's what I'm going to tell you to do. Make sure to get that $500 to $600 paid to the landlord. You can contact plaintiff's counsel. You can contact other places to get some assistance to get yourself caught up. But what you might want to do is call counsel's office and see if you can work out a payment plan on this.
Okay, but they're flexible on that.
Well, I don't know. It's Mr. Cat, so I have no idea.
More my client that he probably wants to talk to than me. So you might want to talk to Six Trails and see what they are willing to work with.
What they will do. All right.
And then.
What
You
kind
hear
of
that, sir?
Yes, sir. What kind of timeline am I looking at before I'm evicted?
Well, you're not anywhere near that right now. All right. So let's not worry about that. Let's figure out and see if you can work something out with the landlord. I'll adjourn this matter out to March 20th, 2025, 26 at
26, Your Honor.
12 noon. And that, sir, is an in-person appointment or court hearing. Okay.
Okay. Thank you, sir.
All right. We'll see you next week.
Bye-bye.
Thank you.
Six Trails versus Sherry Kennedy.
Good morning again, Your Honor. Sidney Katz, I'm behalf plaintiff.
Kennedy? I now only have one screen, so I'm good, but I'm not picking her up.
She's in the wrong job. I'm hunting her now. She's just relaxing.
Is that coming in? Got a message. All right, let me pass that one briefly while we try to get to that person. Six Trails versus Olivia Martin.
Good morning again, Your Honor. Sidney Katz, I'm behalf plaintiff.
I don't have this, Martin.
Olivia Martin.
Olivia's not here at the moment, but I am a resident at that place. We were told that only one of us had to appear.
Who are you?
I'm Devin Curry. I am on the lease here.
Okay, you're also on the lease?
Yes, sir.
All right. Well, Devin Curry.
Yes, sir.
I do see him on the lease. All right, what is plaintiff's claim in this case?
Your Honor, current balance, including costs, is $1,139, 1139.
1139. And sir, how are you guys intending on getting that paid?
I have a check that should be coming in today. It was supposed to come in yesterday, but they had a problem with the payroll at my job. And then in the following 2 weeks, we also get paid again. So we can pay the rest of it, the remaining balance. Then I get paid. It's almost, I think it's $675. So that'll be a payment of $675.
Between now and next week, how much are you going to be able to pay?
Between now and next week, about $750.
All right. Okay, get $750 paid into the landlord. I'll indicate you're going to pay that by the 19th. Okay, if not before.
Okay.
I'll adjourn the matter to March 20th, 2026 at 12 noon. That's an in-person hearing, so you guys will need to appear down at the courthouse. All right. In the meantime, and Mr. Katz, you're suggesting that they contact the landlord directly?
Yeah, and it seems like it's possible that he might be paid up in full by the end of the month based on what he's discussing, because if he's got 750 by next week, that'll leave him under $500.
Okay.
Yeah, I could pay the remaining balance before the end of the month. I have an additional $400 coming from my bank since I just switched to a new bank. So
Your
I
Honor, if
should
you
be able
want,
to-
we can adjourn to the 27th and hopefully we'll just dismiss.
Oh, okay. You have a problem with that, sir?
no, sir, I do not.
All right. I'll adjourn it to March 27th, 2026, 1 p.m. If you have everything paid, you don't need to be here. They'll dismiss the case out. If it hasn't been paid, you guys need to show up. All right?
Sounds good.
All right. Thank you.
Thank you, Your Honor.
Thank you. Thank you for that, Mr. Katz. It's great. Recall,
Thank
6 trips versus Sherry Kennedy.
Right.
Good morning again, Your Honor. Sidney Katz on behalf of plaintiff.
All right, Ms. Kennedy, you there?
Yes,
Okay, she's there. All right, what is plaintiff's claim?
Your Honor, including costs, the balance is $1,922, 1922.
All right. And Ms. Kennedy, how are you intending on getting that paid?
well, I never even knew I owed it, first of all. But I can get it paid within like 2 months. I can have it all paid. I'm on disability, but I have a part-time job too. I'm a waitress at a Sleeping Inn restaurant. So everything I get, I can put towards it.
All right, let's try to work this out. Are you gonna try to get some assistance to try to get this taken care of?
Yes, sir. Yes, sir, I am. I've already talked to Pastor Kimberly from the church here, and she's been sick the last couple of days, so there really wasn't nothing she could do. She had cold or something. So, and I'm going to talk to Hawk about helping too.
All right. Do you have an appointment with Hawk, or you got to still call him?
I still got to call them. Yes, sir.
Okay. So here's what I want you to do. I'm going to adjourn this out to March 20th, 2026 at noon.
Okay.
All right. That's an in-person hearing, so you'll have to come down to the court. In your packet, there's a form called a rental assistance form. Once you get an appointment with Hawk, and I'd suggest that you call them right away. Once you get an appointment with them, you got to submit that form just indicating that you contacted Hawk on the form. Submit that to the court, and it's got to be filed with the court by Wednesday of next week.
Okay.
Okay?
Okay. Thank you so
All right.
much.
Not a problem. March 20th, 2026 at noon.
Okay. Thank you.
Thank you, Your Honor.
Thank you.
Bye-bye.
Thank you. Is that it for you, Mr. Katz?
Yeah, I just had 2 other cases that were dismissed, so it's probably not even on the docket.
That's sure. They're not here. All right.
See you this
Thank
afternoon.
you, sir.
Thank you.
Yes, sir. Orchard Grove versus Patrick Anderson.
Get off here. Orchard Grove. Oh, hang it. Orchard Grove, they're talking about, I can't get off my screen now. There it goes.
We got you. Mr.
Morning, Honor.
Kennedy. All right.
Jeremy Brown, about plaintiff.
Patrick Anderson.
I'm here.
Where's I didn't. That didn't. I'm sorry.
I'm here.
Yeah, I got you. He's on. I don't have a second. Well, maybe I do. I do. All right. No, I do.
Wait a minute. Wait a minute. Here. Okay. I'm here.
All right. What is plaintiff's claim?
The rent to retain possession, including costs, $2,423.68.
All right. Sir?
Yes.
How are you intending on getting that paid?
I have 1474.75 on the docket I'm holding in front of me, which I'm going to pay today, and I can probably pay the rest off by before Friday next week.
Oh, okay. So you can pay about 1470 something, but today,
Yes.
and then you think you'll have it cleared by next week.
Well, I will have it cleared by next week. Yes. Probably before.
Okay. All right. So what I'll do is I'll adjourn this out to March 20th, 2026 at 3 p.m. That's an in-person hearing. If you've got everything cleared and make sure that you got everything paid, then they're gonna likely dismiss the case, and so you don't need to appear. Okay?
Excellent. Excellent.
All right.
Your Honor,
Thank
you
sir.
said 1 o'clock, Your Honor?
3 o'clock.
3 o'clock.
3 o'clock, thank you.
Well, thank you, sir.
All right. Thank you.
Orchard Grove versus Nathan Allport. Paul Cochran and Stacy Allport Jenkins.
Jeremy Brown on behalf of plaintiff.
That's Stacy's here.
I'm here.
Oh.
Nathan and my father Paul are not. My father's passed and my son lives elsewhere. I submitted document to Patrice yesterday, and also
Okay.
she has my father's death certificate.
Okay. All right. They'll take care of that. Your father was Nathan?
No, my father was Paul, and Nathan is my son.
Gotcha. Okay. All right. What is plaintiff's claim in this?
Through the month of March, Your Honor, the rent to retain, including costs, $1,891.58.
All right. And ma'am, how are you intending on getting that paid?
Sir, I have a tracking number from DHS. I filed an SER, and I also have an appointment with Hawk next week.
Okay, what
The
day is your
18th at 11 a.m. Sorry, sir.
The 18th?
Yes, sir, at 11 a.m.
All right. So what you need to do is put that tracking number. There's a form in there, your packet called a rental assistance form. You need to fill that out, indicate on that form that you have an appointment with Hawk and that you also have a SER tracking number. Put that tracking number on there. And that form
Okay.
needs to be filed. That form needs to be filed with the court by Wednesday.
Do I have to come to the court to file it, or can I email it in? I don't have a vehicle.
I think you can actually either email it in or you can call the clerk's office. They'll let you know how you can get that to us.
Okay, thank you, Judge Simpson.
Not a problem. Hold on. I'm going to give you an adjourn date. I'm going to adjourn your case out to March 20th, 2026 at 3 p.m. That's an in-person hearing. So you'll have to try to come down to the courthouse to appear on that date if everything's not paid. Okay?
Yes, sir. Can you guys give me the total one more time so I can give it to Hawk?
Sure. I have $1,891.58.
Thank you, sir. Have a blessed week.
You do the same.
Thank
Bye-bye.
you, Your Honor.
Thank you, sir. And I think we got one more for you. And that's Pines of Clover Lane versus Eduardo Handel. And
This is a dismissal, Your Honor.
that's a dismissal? Okay.
Yes.
That case is dismissed on plaintiff's motion without prejudice. They weren't here.
Excellent.
Were they?
Thank you, Your Honor.
All right. Thank you, sir. Harbor Woods versus Angela Bogard.
Good morning, Your Honor. Rachel Dornbush, Palace Law, on behalf of the plaintiff.
Don't have any.
Angela Bogard. There is no response. If you'd like to take the poll, raise your right hand.
Yes.
Okay. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole
I-
truth, and nothing but the truth, so help you God?
I do, Your Honor. For the record, Rachel Dornbush, Palace Law, on behalf of the plaintiff. Your Honor, just so the court is aware, Ms. Bogard called our office around noon yesterday. I didn't get a chance to give her a call back. She had indicated, she didn't mention, as far as I can tell in her voicemail, that she didn't intend to be here today. But nonetheless, she had indicated that she planned to pay $1,400 today and then the remaining balance on the 27th. And, you know, had she been here today, then she would have obviously received the adjournment and almost certainly would have had
Had
that
been
time
by
frame.
that time.
But I, since she's not here, I don't have the ability to extend to the 27th. So I would request entry of the default judgment with the statutory 10-day period. The rent to retain is $1,588.63. Costs are $188 for a total due of $1,776.63.
Judgment to the plaintiff, that is by default for possession, redemption amount, any amount requested with a writ to issue in 10 days. I think if she gets in there and starts banging, I think your client's probably will. So I'm not so worried. Arbor Woods versus Tina Carico. Tina Carico, no response. You may proceed.
Thank you, Your Honor. There is rent to retain of $1,765.84. The costs are $188 for a total due of $1,953.84. We ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ to issue in 10 days. Arbor Woods versus Daryl Corley and Stephanie Corley. Daryl or Stephanie Corley? No response. You may proceed.
Thank you, Your Honor. There is rent to retain of $741.20, cost of $246 for a total due of $987.20. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession. Redemption amount is any amount requested, writ to issue in 10 days. Arbor Woods versus Courtney Cruz and Devin Cruz. You got him?
No.
Devin, Courtney Cruz, no response. You may proceed.
Thank you. Yes, Your Honor. Yeah, the rent to retain is $1,817.72. The costs are $246 for a total due of $2,063.72. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession. Redemption amount, any amount requested, writ to issue in 10 days. Arbor Woods versus Charles Hardy. Okay, Mr. Hardy, you need to unmute. There you go.
Good morning, Your Honor.
Good morning. And what is plaintiff's claim in this case?
With costs, Your Honor, $2,307.52.
All right. And Mr. Hardy, how are you intending on getting that paid?
Well, I would be able to make a payment today, or at least by Monday. I will be able to make a payment of $900. I will be able to make another payment of $700 by Friday, this coming Friday after. The remaining amount I would need until the following week after.
Got it. I see what you're saying. Okay. And the following week after then puts us, however, into April. So here's what I'm going to do, sir.
And I will actually also be able to make the full payment for April.
Got it. Okay. But what I'm going to do is I'm going to adjourn this out to March 20th, 2026 at 1 p.m. That's an in-person hearing, so you'll need to be down at the courthouse. What I'm going to suggest is that you contact, that you pay the $500, and then you contact plaintiff's counsel's or plaintiff's office, plaintiff's attorney's office, and see if you can work out some agreement regarding payment of this amount.
Yes, Your Honor.
All right, very good. We'll see you then. All right, thank you. Arbor Woods versus Melinda Harrison. Melinda Harrison, no response. You may proceed.
Your Honor, I think I thought I saw her signed in.
You did?
I thought so, but let me double check. Maybe I'm mistaken.
Alex, but that person is not currently present.
There was a who? Oh, a Mel.
Maybe that's what I saw, Your Honor. I apologize. I try to click through and make sure I don't miss anybody and to see if
No.
dismissed tenants are here. So, Your Honor, there is rent to retain of $637.72, cost of $188 for a total due of $825.72. Would ask for a default possession only judgment with written issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ issue in 10 days. Arbor Woods versus Marcus Hollis. You think he's here?
Yeah.
Yeah, I'm here.
He's there. All right. Got a camera too. All right. What is plaintiff's claim?
Would cost, Your Honor, $3,668.94.
94. Got it. All right. So Hollis, how are you intending on getting that paid, sir?
I just need a couple weeks.
I'm sorry?
I just need a couple weeks.
Okay. How much can you pay by next week?
All of it.
Pardon?
All of it.
So you can have the balance paid by the 20th?
Yep.
Okay. I'll indicate that in the file by the 20th. I'll adjourn this out to March 20th, 2026 at 1 p.m. That's an in-person hearing. So if it's not paid in full, you'll need to appear at the courthouse on that date and at that time. Okay, sir?
Okay.
All right. Thank you.
Appreciate it.
Court calls the case of Arbor Woods versus Eric Stewart and Gene Wesley.
Yes, I'm here.
Okay, there he is. All right. And what is plaintiff's claim on this?
With cost, Your Honor, $3,944.37.
All right. And sir, how are you intending on getting that paid?
It was already paid.
You've already paid it?
Yes, I did. It was paid yesterday.
Okay, so yesterday, so we probably hasn't caught up yet. So I'll indicate that you say you paid it. I'll adjourn it out to the 20th, 2026 at 1 p.m. That's an in-person hearing, but if everything's paid, you don't need to come down and they'll be dismissing the case out, okay?
Okie dokie.
All right, thank you, sir.
Yep.
Arbor Woods versus David Waters. David Waters, not checked in. You may proceed.
Thank you, Your Honor. There's rent to retain of $617.72. Costs are $188 for a total due of $805.72. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff. That's by default for possession, redemption amount, in the amount requested, writ to issue at 10 days. Arbor Woods versus Jessica Wakeham. Jessica Wakeham?
Hi, Your Honor, I'm here. Yes, good morning, Your Honor.
Okay, she's on the phone. Got her. Okay. All right. Ms. Wakeham. What is plaintiff's claim?
With costs, Your Honor, $1,958.38.
All right. Ms. Wakeham, how are you intending on getting that paid?
Today I can pay about $650, and then in 2 weeks I can probably pay throughout the 2 weeks the remaining balance.
Say that again.
Today I can pay $650, and then throughout throughout the 2 weeks I can pay the remaining balance.
Okay, are you going to be able to get it, you think, paid before the end of the month?
Yeah.
Okay, so here's what I'm going to do. You pay the $650. I'll adjourn your case out to the 20th of March 2026 at 1 p.m. That's an in-person hearing, so if everything's not paid in full, you need to come down to the court. Okay?
March, that's 1 week away.
That's 1 week away, right, at 1 p.m. What I'm going to suggest in the interim, what I'm going to suggest in the interim is that you contact the plaintiff's attorney's office and see if you can work out a payment arrangement and a conditional dismissal, because you're going to try to get this paid before the end of the month in any event.
Okay.
All right?
Okay.
Okay. All right. Thank you.
All right. Thank you. Bye-bye.
Arbor Woods versus Nancy Yevich. Nancy Yevich, no response. You may proceed.
Thank you, Your Honor. There's rent to retain of $323.97. Costs are $188 for a total due of $511.97. We'd ask for a default possession only judgment with a writ to issue after 10 days.
Judgment to the plaintiff by default for possession. Redemption amount in the amount requested. Writ to issue 10 days. Northville Crossing versus Jessica Bradshaw. Jessica Bradshaw, not checked in. You may proceed.
Thank you, Your Honor. There is rent to retain of $1,865.98. Costs are $192 for a total due of $2,057.98. We ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession. Redemption amount in the amount requested. Writ to issue in 10 days. Northville Crossing versus Courtney Brown and Andrea Brown. Courtney Brown, Andrea Brown, no response. You may proceed.
Thank you, Your Honor. Let me just look at this. Your Honor, I've got them at a balance of $108.08. So they've made payments. They just have not been, unfortunately, been paying in full. And so, let's see here.
You said $108. That includes after you factor in cost and
everything, factoring in the court costs. Just, I'm not sure why. I mean, and looking at their ledger, Your Honor, it does appear that they kind of have a history of piecemealing their payments. And so,
well, what I'll do is I'll grant you a judgment for, you said 108?
Yep, 108.08.
Okay, 108.08. I'll grant a judgment by default for that amount with the writ issue in 10 days and just indicate no writ without a hearing.
Thank you, Your Honor.
Oh. Northville Crossing versus Leonard Burns III.
Here.
Oh, okay, there you are. All right. What is plaintiff's claim?
Well, with cost, Your Honor, $3,124.29.
All right. And sir, how are you intending on getting that paid?
My disability check is going to be coming because I was off for 2.5 months. And with my company got bought out by a different company. So stuff got messed up with my health insurance. I had a broken foot, and so I'm supposed to be getting that check this week, and then I can have everything caught back up, and I'm back to work now, so I can have everything back to where it's being paid on time.
Gotcha. Okay. So you think that's coming this upcoming week?
Yeah, I got approved yesterday, so they said allowed us 7 to 10 days for payment to come in the mail.
All right. Here's what we'll do. I'll give you an adjournment to the 20th next week, 2026 at 1 p.m. That's an in-person hearing, sir. Okay. And so if it's not paid by that point, you'll need to appear down at the courthouse and we'll figure it out. In the interim, you can also contact plaintiff's counsel's office, knowing, because you know that there's a check coming. See if you can work something out in terms of payment. Okay?
Now, the property doesn't let me pay online for some reason anymore. And I did put a money order in the after hours box, but they said they never got it, which, you know, it is what it is at that point. But this was a while back. I was wondering, is there a way they can turn back on where I can pay my payments online? Because I don't have to work.
Your Honor, I suspect the issue here is that if Mr. Burns is attempting to go in and make payment less than the full amount, that's probably the issue that he's running into, is the portal won't accept payment less than the full amount. But definitely speak with Bobby in the office to verify that their access is intact. I was looking, Your Honor, to see if there was a returned payment, which sometimes can affect access to the portal. There was one back in September, and generally speaking, that results in a requirement of payment via certified funds for a period of time. So that might be part of the issue. Mr. Burns, definitely speak with Bobby in the office. She can verify with you if that NSF is the issue or if it's because you're trying to make a partial payment on the portal.
Every time I try to call up there, no one's ever, I mean, I know like I'm trying to call probably during lunchtime or whatnot, but I'll just have to try to call at different times of the day or whatnot, because it's very hard to get a hold of people up there sometimes.
Got it.
Or
right.
stop in there,
give it a
Mr.
shot.
Burns.
Yeah, I try, but every time I get home from work, they're closed.
All right. All right. Just give it a shot. See what you
I
can
will.
do. Otherwise, we'll see you next week. All right,
All
sir?
right, thank you.
Thank
You have a
you.
good day.
You do the same. North Crossing versus Cynthia, is it Foch? Cynthia Foch? No response. You may proceed.
Thank you, Your Honor. There is a rent to retain of $727.48. Costs are $192 for a total due of $919.48. We'd ask for a default possession only judgment with a writ to issue after 10 days.
Judgment to the plaintiff by default for possession. Redemption amount in the amount requested. Writ to issue in 10 days. Northville Crossing versus Otia Fowler. Ms. Fowler, she's there.
I'm here.
Oh, there she is. All right. What is plaintiff's claim?
Yeah, with costs, Your Honor, is $3,141.28. And Your Honor, just to verify, it looks like a defendant has her name spelled O-N-T-I-N-A. We have it as with an N.
There's no N. It's just O-N-T-I-A.
Is that correct? Okay, I wanted to make sure because the ledger has it the way that we have it, but I noticed it was slightly different there. So, okay, clarifying.
All right. We fixed it. Now Renee's back to what it should be. All right. Ms. Fowler, how are you intending on getting this paid?
So I'm waiting on DHS and our Salvation Army. I actually got an appointment with DHS on the 17th, a phone call interview, because I did a SCR application online. So
okay, so you did
waiting
an
to see
SCR.
how much. Yeah, I'm trying to see how much my portion would be, and then what they would pay.
And then you said you called SOS, so you called Hawk. Do you have an appointment?
You said Hawk? Is that I've never?
Yes. Never do. Okay, let me give you a phone number.
Okay. Okay.
All right, 734 961 1999.
961-1999. Okay.
Okay, give them a call. See if you can get an appointment set for yourself regarding them. Okay.
Okay.
And what the other thing that you need to do in your packet, there's a form called a rental assistance form. When you have your tracking number, or if you have your tracking number from DHS, you need to put that on the form, file that with the court by next Wednesday.
Okay.
Okay, do that. How many people are in your household?
Myself and my 2 daughters.
Okay, so 3. Okay, so just so you know, the amount that DHS has here, would the maximum amount that looks like they pay is $620. Just so you can try to figure it out in your head. Okay, I'll just give you that number.
Okay.
Okay, so I'll adjourn this to March 20th, 2026, at 1 p.m. Okay, that's an in-person hearing, so you'll need to come down to the courthouse.
On the 20th?
Yes, ma'am.
Okay.
All right.
Okay.
Thank you. Northfield Crossing versus Daniel Glosky and Michael Glosky. Neither here. You may proceed.
Thank you, Your Honor. There is rent to retain of $1,834.41, cost of $250 for a total due of $2,084.41. We'd ask for a default possession only judgment with right to issue after 10 days.
This must count two altogether. So that's voluntary. You are a U.S. citizen. There will be restitution, which would be $1,089. Police control. They're going to give you between 1 and 3 years of parole supervision when you get out. But you're already going to get anything. And then the judge will tell you if you get a new felony while you're on parole, they can give you more time and all that stuff. I'll go through all this to post police control if you get a new felony.
All right, this is case number 25CR42859, the state of Ohio versus Marcy Russell. Ms. Nicholson is here on behalf of the state of Ohio. Ms. Russell, I had you brought back because after you had been sentenced by me, I was told that you had been sent to prison, correct?
Yes, sir.
Now your out date is sometime in July or August of this year?
July 27th.
July 27th. It was my thought that where do you live? Where are you from? Okay. It was my thought that after discussing with counsel and probation that perhaps adding time onto your sentence wasn't the best thing for me to do. So what I did was, when I originally was having you brought back, my thought was I'm just going to add time onto your sentence and be done with you. But I've rethought that. What I'm going to do is allow you to serve out your current sentence. We're going to place a holder on you so that when you are released from prison, you will be transported back to the Warren County Jail. And I'm going to continue at that point in time with what my original thoughts are to get you treatment. You okay with that?
Yes, sir.
Okay. Everyone seemed like yesterday when we had everybody together yesterday that everybody kind of agreed that you need treatment. Do you agree with that?
Yes, sir.
Okay. So that's what I'm going to do. Rather than adding time, I'm simply going to bring you back in July, and we'll do what we originally planned to do. Okay. All right. You can have a seat. Thank you. Thank you. Case number 25CR43275, the state of Ohio versus Melissa Moore. You are Melissa Moore?
Yes, Your Honor.
Ms. Moore is before the court with her counsel, Mr. State and Ms. Nicholson, on behalf of the state of Ohio. Ms. Nicholson.
Your Honor, it's my understanding the defendant will be entering a guilty plea to count 1, the robbery, a felony of the 3rd degree. The state will dismiss count 2. There is no agreement on sentencing.
All right, Mr. Staten, is that accurate?
That is correct, Your Honor.
All right, Ms. Moore, they're telling me that you're going to change your plea to guilty to 1 count from the indictment. Before I get to your change of plea, I am required to go over some things with you, okay?
Yes, Your Honor.
How old are you?
38.
How far did you go in school?
I got a bachelor's in science, criminal justice, law enforcement, administration degree.
Wow. Wow. All right, so but you can read and write okay, right?
Yes.
And you're a citizen of the United States.
Yes.
Now, has anyone promised you how the court would sentence you other than I represented to your attorney, Mr. Staten, that it was my intention upon a plea of guilty that I was going to sentence you to 24 months in prison, that to be served consecutive to your current sentence? Has anybody made any other representations to you?
No, sir.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you satisfied with the representation you've received from Mr. Staten?
Yes, sir.
Are you currently under the influence of any drugs or alcohol?
No.
Do you take medication that interferes with your ability to understand what's going on today?
No, sir.
I have in front of me a document. It's called a change of plea. On the second page, on the line marked defendant, there is a signature. Did you sign this?
Yes.
Did you read this and go over it with your attorney before you signed it?
Yes, Your Honor.
And you believe you understand what it says?
Yes, Your Honor.
This document says you're entering a plea of guilty to 1 count of robbery as a felony of the 3rd degree. That carries a maximum penalty of 36 months in prison and a maximum fine of $10,000. Do you understand the maximum penalties?
Yes, Your Honor.
You're also subject to a mandatory period of post-release control, which means upon your release from prison on this charge, the adult parole authority will supervise you for up to 3 years, but not less than 1 year. If you violate those rules of supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, Your Honor.
Now, you are presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, Your Honor.
You have the right to trial by jury. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, Your Honor.
At that trial, you have a right to see and hear all the evidence that the prosecutor has against you. With the help of Mr. Staten, you have the right to confront and cross-examine each of their witnesses. Do you understand that?
Yes, Your Honor.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, Your Honor.
You have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you. And I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, Your Honor.
Now, the burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense. And if you do not, that will not be held against you. Do you understand that?
Yes, Your Honor.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, Your Honor.
Now, you could also waive your right to a jury trial, but maintain all the other rights we've discussed. You could try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt or would be required to find you not guilty. Do you understand that?
Yes, Your Honor.
Do you believe you understand each of these rights that I've described?
Yes.
Do you understand that when you enter a plea of guilty, you'll be waiving all these rights? We will not have a trial.
Yes.
This is how you wish to proceed.
Guilty.
No, do you want to proceed with a plea and not a trial?
Yes.
All right.
Yes, with the plea.
All right, she's going to read a statement of facts. I need you to listen to that, Ms. Nicholson.
Your Honor, if this would have proceeded to trial, the state would have proven that on or about December 10th of 2024, in the city of Lebanon, Warren County, Ohio, the defendant entered People's Bank on Columbus Avenue. She then exited the bank, went back in about 5 minutes later, approached a teller stating, "This is a robbery, give me the money." The teller questioned that. The defendant replied that yes, it was a robbery. The teller gave her $1,089. At the time, the defendant had on black gloves, a mask covering her face, a hoodie, and thick black framed glasses. She then exited the bank with the cash.
Mr. Staten, anything on those facts?
No, Your Honor.
Ms. Moore, did you hear the statement that she read?
Yes, Your Honor.
Do you admit and acknowledge that what she said is true?
Yes, Your Honor.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we went over.
Yes.
What is your plea?
Guilty.
The court will make a finding then that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court will accept your plea of guilty. And based upon the statement of facts in your plea, the court will make a finding of guilty. Anything before I sentence her?
We would ask for restitution in the amount of $1,089 to People's Bank. Aside from that, as we discussed in chambers, this is now her third robbery conviction. Then she is currently serving a prison sentence for a robbery.
Well, you have a jail time credit?
She has 0 days here.
Anything, Mr. Staten? Ms. Moore, is there anything that you'd like to say?
I would like to say I apologize for my actions. I know it was not right. I wasn't in the right state of mind, and I apologize.
Well, I tell you, after you told me about your education, I'm actually a little bit shocked to see you standing before me. I believe this is your third conviction for a robbery. I don't understand. I mean, you have the mental capabilities to go out and earn a living rather than stealing from other people. but committing 3 robberies, that's just shocking. All right, the court has considered the statements made here today, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. I know that there was no weapon used here, and that, according to Mr. Staten, that perhaps you don't feel that you instilled some fear in the teller, but that's still a pretty traumatic experience as a teller to be robbed. So I'm going to do what I told Mr. Staten I'm going to do. I am going to order you to serve 24 months in prison, that to be served consecutive to your current sentence. A consecutive sentence is necessary to punish you. It is not disproportionate to the conduct or the danger that you pose to the society, and that this offense was committed while you were awaiting trial or under indictment on another case of similar import. So you have 0 days jail time credit on this case. I'm going to order restitution in the sum of $1,089 to People's Bank. Other than that restitution, the court will find that you are indigent for the purpose of other fines, costs, or financial sanctions. You're also subject to the mandatory penalties for you to receive up to 1 day per month credit for certain participation in certain programs sponsored by the Department of Corrections. And finally, you do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. Ms. Nicholson, is there anything else?
No, Your Honor, thank you.
Mr. Staten?
Nothing much, Your Honor. Thank you.
Best of luck to you.
Thank you, Your Honor. Thank you.
Yes.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested with a writ issue in 10 days. Northville Crossing versus Jose Gonzalez Ramos and Christina Gonzalez.
Present. Christina Gate.
Oh, where is she? Oh, there she is. All right.
Yeah.
Okay. And what is plaintiff's claim in this case?
With costs, Your Honor, $2,404.64.
All right, Ms. Gonzalez, how are you intending on getting that paid?
I can put 500 down today, or well, it'll be tomorrow because my son's at work. My son failed to tell me that he had paid the lot rent, so I am going to cover it. I'll have to do it within the next 2 weeks.
Okay, so you put 500 today.
Well, it'll be tomorrow because by the time he gets off today, the office will be closed.
That's fine. Okay, so
Okay.
you'll put 500 by tomorrow. All right.
Right.
So here's what I'll do. I'm going to adjourn this out to March 20th, 2026 at 1 p.m. That's an in-person hearing, so you'll need to come down to the courthouse.
Okay.
All right. In the interim, what I'd suggest that you do is, if you're not seeking assistance, is contact plaintiff's office, the attorney's office, see if you can work out some type of payment plan, conditional dismissal, or the like. Okay.
Okay. All righty. Thank you.
All right. Thank you. Northville Crossing versus Christina Johnson. Christina Johnson and Ann Rowe. Johnson, Rowe, no response. You may proceed.
Thank you, Your Honor. There's rent to retain of $620.77, cost of $250 for a total due of $870.77. And we'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, the writ issue in 10 days. Northville Crossing versus Stephen Kilgore and Dana Kilgore. Stephen or Dana Kilgore, no response. You may proceed.
Thank you, Your Honor. There's rent to retain of $2,000. $146. Actually, you know what, Your Honor, there's a note here indicating that there was a payment made on the 3rd that would clear it, the balance, but I don't have verification that it's cleared. The payment has cleared. Could we adjourn this one for 1 week?
Absolutely. I'll adjourn this matter March 20th, 2026, 1 p.m. Court calls case of Northville Crossing versus Brendan Kuzma and Ashley Kuzma. Brendan, Ashley Kuzma, no response. You may proceed.
Thank you, Your Honor. There is rent to retain of $3,237.20, cost of $250 for a total due of $3,487.20. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession. Redemption amount in the amount requested. Writ to issue in 10 days. Northville Crossing versus Bobby Lambert and Haley Lindsay. Lambert, Lindsay, no response. You may proceed.
Thank you, Your Honor. There's rent to retain of $3,767.25, cost of $250 for a total due of $4,017.25. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ to issue in 10 days. Northville Crossing versus Faithlyn Lefker. Lefker? There is no response. You may proceed.
Thank you, Your Honor. There's rent to retain of $1,936.17, cost of $192 for a total due of $2,128.17. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff, that's by default for possession, redemption amount in the amount requested, writ to issue in 10 days. Northville Crossing versus David, is it Mikulinski? And
Mikulinski, Your Honor.
Okay, and Nicole, is it Gasak?
Gasho.
Okay, I blew them both. All right,
I'm not sure. I'm not sure if she's still here or if she logged off. She was on here with me.
She was on? Okay.
Yeah.
But she
might have logged off.
All right. What is plaintiff's claim?
With cost, Your Honor, $1,001.42.
$1,001.42. All right. And sir, how are you guys intending on getting that paid?
Your Honor, I am 100% paid up through March right now. I've noticed a discrepancy on this paperwork. It says that I was paid up through 12/31 and then I owed costs. Her date for her demand of lot rent was February 6th, which was 2 weeks after I paid it. I've got ledger.
Hang on.
Sorry.
You're talking about the complaint saying the date that you're paid through, right?
Yep.
Okay.
Yes, sir.
All right. So that you understand that that's going to be basically a pro rata calculation as to the date that you're paid through.
And Your Honor, we can provide some additional clarification on that. The way that it's calculated is based on if the balance owed at the time of the demand exceeds what the base rent is, then it backs it up to the last month prior to that.
Got it. Okay.
So it counts for the base rent, but there's water, sewer, other charges that are charged over and above that. And so that's why it says paid through December, because the balance due as of February 6th was more than just the base rent because of those other charges. I can verify defendant did make a payment on January 23rd of $960 that brought his account current at that time. We've shown his February payment being made on February 27th. It left a small rollover balance coming into March. If defendant has said he's now paid his March balance, if he can confirm when it was paid, my ledger was prepared on the 10th. And so I'd have to verify with my client.
I have the receipt right here in my hand.
Okay. What date did you pay it, sir?
I paid it yesterday, 3/12.
And you paid how much? It says 9 something on there.
This was $960 on my ledger through the Sun Communities site. I owed $940, so I should have a credit right now.
So the slight issue with that, Your Honor, is that it looks like my client had the court costs at $244. They're actually $250, so there's a $6 difference. And then there is, let me just see, there was not a $55 late fee was not showing either, which came due on the 6th.
The 6th for?
Of March.
If you look at the base rent, my base rent is $767. When you total everything together, if you look at the top of the demand for possession, it shows where my base rent is, trash service, amenity fee, and all that. With the late fee, it shows $955 for the 1 month, and I paid $960.
That's for February. Are you looking at the February demand, sir?
That's the one that was attached to the paperwork, yes.
Correct. That was issued in February. So with your March charges, you were at $940.42 on the portal or on the ledger. That was as of March 1st. That didn't account for the increase in court costs. So add on $6 to that, $946.42. Additionally, a late fee comes due under your lease agreement on the 5th of the month. I'm sorry, for balances that roll over after the 5th. So it was due on March 6th. I'm not sure why it's not showing up on the portal, but that increases the balance by an additional $55. So that gets us to the $1,142.
After my February payment, my balance was $0. So I should only have the amenity fees with the late fee added in to where it only would come.
You didn't listen. There was a small balance after your February payment, which is why it rolled over into March.
Correct. It was $49.12, Your Honor.
I don't understand why that did not reflect on the portal when I show that.
Okay.
Everything always pops up.
All right. Here's what I'm going to do. You
I
can
can
go
pay it
down to
today.
the
That's
office. Okay. If you're going to pay it today, that's fine. What I'm going to do is, because I can't resolve this, is I'm going to adjourn this to March 20th, 2026 at 1 p.m. That's an in-person hearing. You need to be at the courthouse if there's still a dispute as to the amount that's due. I'd suggest that you go to the office, look at a paper ledger, look at the charges. If you dispute the charges, you can come down to the court on the 20th.
Okay, because after last month it said $1,155 and I paid $1,200. So, or 11 something, I paid $1,200. So I thought I was good.
Again, I can't resolve it. I don't have that in front of me. I hear you.
Yes, sir.
But go down to the office, get a ledger, look at it. If you still have a dispute, you have a court hearing that's set for next week. If you pay it off, you don't need to be here and the case will be dismissed. Thank you.
Thank you.
Northville Crossing versus Tony Rogers.
I'm here.
Tony Rogers?
Yes.
Is she here?
Yes.
Okay. Gotcha. Okay. And what is plaintiff's claim on this case?
With costs, Your Honor, $2,064 even.
Penny. Thank goodness, no change. All right. I'm sorry. Ms. Rogers, how are you intending on getting that paid?
I can drop off a down payment on Monday for $800, and I can pay the remaining balance on the 24th.
Okay. Here's what I'll do. I'm going to adjourn it out to the 20th, 2026 at 1 p.m. That's an in-person hearing. What I'm going to suggest you do in the interim is contact plaintiff's attorney's office and see if you can work out an agreement to get you to that date. Okay?
Okay.
All right. Fantastic.
Thank you so much.
Thank you. Take care.
You too.
Northville Crossing versus, is it Heaven Schulthesis?
Yeah, Heaven Schultes and William Brokenshire.
I'm
I
sorry?
already have, it's Heaven Schultes and William Brokenshire. I have the money
that's
order.
it. Hang on. Hold on. Ma'am, hold on just a second.
Right here. I can drop them off for you.
Just, ma'am, please, because I don't have the amount right now. I'll hear from you. All right, just hold on. What is plaintiff's
11.
claim in this case?
With costs, Your Honor, $2,431.53.
All right.
What?
Now, ma'am, what did you want to tell me?
Well, what I got told was that it was $1,188. So I have a $1,200 money order right here to drop off later.
Okay, how
That's
much?
what was due on the complaint.
So I'm not exactly sure like what's going on because
Ma'am, ma'am, you got to face your microphone, please.
sorry, I had earbuds in. I have been having nothing but issues with these people for a while, but I have 1,200 right now to give them today.
I could not make that out.
Your Honor, she indicated she's had nothing but problems with these people, but nonetheless, she has $1,200 to give them today.
Okay. All right. So you're going to pay $1,200 today, correct, ma'am?
Yeah, because that's what's on the complaint. Yep.
All right. Pay the $1,200 today. When do you think you're going to be able to make the balance?
Sure, because I didn't even know that was my balance.
I'm sorry?
I'm unsure because I didn't even know that was my balance.
Okay. There's going to be a balance, probably about another $1,231.53 if you pay the $1,200.
Is there any way someone can mail me a copy of that breakdown? Because I don't have that breakdown available to me on how it got to be that much. Because the only thing that I have is that it was $1,188 and some odd change.
All right. Here's what I'm going to suggest you do, ma'am. You need to go down to the office, get a copy of your ledger, pay the $1,200. If you, after looking at the ledger, you still have a dispute or don't understand why you owe that, then I'm going to set this for a hearing in person, March 20th, 2026 at 1 p.m. You need to come down to the courthouse.
Agoraphobia.
I'm sorry?
I have agoraphobia.
Okay.
So
Then,
it's
ma'am,
Zoom
what
one?
you can do is you can file a request to appear via Zoom. I'm not sure whether I'll grant it or deny it, but I know that now knowing that I may grant it, and then you'll have a hearing next week at 1 p.m.
Okay, that sounds awesome. Thank you so much. I appreciate you.
Thank you. Court calls the case of Northfield Crossing versus Tiffany Stevens. Ms. Stevens is here.
Yes, I'm here, Your Honor.
Okay, there she is. All right. And what is plaintiff's claim?
With costs, Your Honor, $3,586.82.
All right, Ms. Stevens, how are you intending on getting this paid?
So I just got a job. I start March 20th. I did speak with Bobby via email. We did discuss me paying about $1,300 via my income tax, which I'm waiting on that. It should be here within like the next 2 weeks. And then she said I could possibly get on a payment plan with my new job as long as we can make an agreement of how much I'm paying per check. That also helps me stay current with the current rent.
Gotcha. All right.
I am applying for SER and Hawk as well for further assistance, as I have 3 small children. But you
hang on a second. Hold on. You applied. Did you say you applied for it?
No, I said I'm attempting to apply this week.
Okay. So here's what you do. And how many people are in your household?
Myself and my 3 children.
Okay. So just so that you have a framework in your head, SER would pay a maximum of about $740, okay?
Okay.
So you also have Hawk that you're going to contact today?
Yes.
Okay. And so contact them today, get an appointment. In your packet, there's a rental assistance form. You'll need to fill that out, put the information, your tracking number for your SER, and that you contacted Hawk, and submit that to the court by Wednesday.
Okay.
Okay? And then I'm gonna set a new hearing date for you of March 20th, 2026 at 1 PM. That's an in-person hearing, so you'll need to come down to the courthouse, okay?
Your Honor, is
And
there a way I can get a different court date as that is the day that I start my job?
Okay.
I didn't
What,
want
you
to
don't-
not show up.
You don't
on my
want to
first
get
day.
fired? You don't want to get fired that day?
No,
Is that what that is?
not on my first day.
Yeah, all right. I really don't have authority to go out longer than that, but I also don't, you're not gonna, if you don't have a job, you're not gonna get the assistance through Hawk. So it's kind of a catch-22. Do you have anything you can pay in the interim?
As of today, no. I'm leaning on the income tax. It's taken a while to come. I don't know if it's just because, you know, what was going on.
It's because it's the federal government. Just don't worry about it. I get it. I believe you, and over the objection of plaintiff, I'm going to give you 2 weeks. I don't want you to lose your job. All right, we probably won't have an answer.
Yeah, I worked really hard. I just
Here's what.
medical school.
Right.
And,
Hang on a second. Here's what I want you to do, though. Did you already apply for your SER?
I did put an application in for the SER.
Do you have a
contacted
track?
Hawk yet.
Hang on. Do you have a tracking number?
I don't know. I would have to check DHS to see if it's one in there.
Okay, I'm sure there would be one in there if you applied. That form that I'm talking about, I'm just going to give the extra week right now so you don't lose your job. I'm going to go to the 27th. I need that form down here, though. If you have the SER tracking number, it's best if you can get me that file today.
Okay.
Okay. All right. I'm doing that over the objection of plaintiff, but I think it's the right thing to do. Pardon? It's at 2 PM on the 27th. Okay?
And that's in person, correct?
That is in person. Yes, ma'am.
Thank you.
Thank you. Northville Crossing versus Cassandra Studer and Cheryl Richter.
Cheryl Richter present.
All right. You said Miss Studer's here? Thought.
Good morning.
Good morning, Your Honor.
Ms. Lafferty and Mr. Wilson, if you would rejoin me.
Yes, sir.
We got another party logging in here. Give me just a moment. Good morning, Mr. Nate. Can you hear me?
Yes, sir. Good morning.
Good morning. It's Friday here. In your case, there was counsel on the other side, although Ms. Oy told me she was leaving or taking a different position. Have you had contact with anybody in your case?
We did. And this one's all set. We did get a signed consent judgment back, I think, just this morning.
All right. Well, let's take care of yours, and then we'll take care of Ms. Escamilla. Let me call the case. This is file 252551GC. It's entitled Resurgent Receivables versus Brian Siebold. The esteemed Mr. Preston Nate is here on behalf of the plaintiff. The defendant is not here. The defendant does have an attorney file an appearance on their behalf. But from what I recall in last meeting with her, she was going to be leaving to take another position. So I'm not sure what her status is. Anyway, as I stated, the file number is 252551. It's a claim for $588.18, which certainly seems resolvable. Mr. Nate, what's the status here?
So we did get this one resolved. We have a signed consent judgment from both parties as of this morning, so I will be able to get that submitted to the court. For a brief rundown of the terms, it's a regular judgment. We are going to settle this at $450 at $25 a month starting April 11th. But I will get that into the court as well.
All right, thanks for letting me know. I'll await that consent judgment. We are doing we're moving. And so the staff's all blue jeans today, but somebody should be manning the 3B civil address, ST Joseph County, 3B civil at stjosephcountymi.gov, or we'll get it in the mail. But I'll indicate consent judgment is forthcoming. Yeah. All right. Thank you. Thanks for checking in.
You bet. Thank you, Your Honor.
All right. Let's talk about our next case. The defendants were here early. This is file 251578GC. It's entitled Omni Community Credit Union versus Chelsea Lafferty and Kevin Wilson. Ms. Lafferty and Mr. Wilson are here this morning from their mobile world headquarters. And Lena Escamilla is here on behalf of Omni Community Credit Union. Ms. Escamilla, I don't know if you know this, but Omni Credit Union got seriously damaged by the tornado last Friday. So the Three Rivers Omni is closed because of the tornado damage. Anyway, this is a claim of substantial size for district court standards, $19,474.44. This matter was set for a while ago, but Ms. Escamilla was ill, and so we reset the matter for this morning. This is set for a motion for summary disposition. Ms. Lafferty and Mr. Wilson, you probably don't know what that means, but the plaintiff did file the motion, and they filed a brief in support of it. Essentially, what it means is that there's no dispute. A motion for summary disposition, as it was filed here, the plaintiff alleges that there is no material issue of fact that the debt is due and owing, and you haven't stated a valid defense. Now, they filed this claim, it was served on you, and you filed a very brief statement, which we accepted as an answer. Response: we never purchased a truck from Royal RV. We test drove a truck from there, but it turned out to be a flood truck. So is it your contention that you never signed a loan with Omni Credit Union? There are certainly a lot of documentation. Now, you did object to the adjournment, and you also asked that the matter be dismissed. But Ms. Escamilla has a long history with this court of credibility, and she was sick, like flu sick. And so the matter was adjourned, and there's no reason to object. It just is what it was. So Ms. Escamilla, their contention somehow is that they didn't purchase a vehicle from Royal RV. You have filed a loan agreement with Omni Credit Union. What can you tell us about this?
Yes, Your Honor. So they did file the loan agreement, and my understanding is they also have had another loan with Omni, so it's not something new. And that basically something happened after they purchased the truck. But again, you know, their deal, we just provide the funds, or Omni provides the funds. They don't have anything to do with the actual dealings between the dealership and Wilson's. So they did sign it under, the Michigan court rule I cited, that they didn't deny and file an affidavit that it wasn't their handwriting. So pursuant to that, it should be under the court rules, prima facie evidence that they did sign the documents. And we did everything, or Omni did everything they could to lessen to lower the damages for them. They tried to explain to them that once they purchased it, that they were responsible, but I don't know what happened with the vehicle. It's unfortunate, but our contention is they didn't follow the Michigan court rules and as far as their responses, so everything should be an admission, and they also didn't deny the handwriting on that loan document. So we would ask that the court enter a judgment in our favor.
All right, Mr. Wilson, what's your response?
Sir, it's a lot more complicated and involved than that. This is the third truck that we attempted to purchase through Omni. Their vetting process, sir, is obscene. I've looked to buy a truck in Florida. I looked to buy a truck in North Carolina. I looked to buy a truck in Michigan, and then finally in Indiana. Now, each one of those loans, we went to go pick up the truck was subpar. It was check engine lights not running right. Every single time this has happened, Omni's worked with us through their offices here, local. Chelsea's actually went to high school with a couple of people that work here. They know each other well. The day that we went to go get this third or fourth truck from a different loan, it comes back. It's just got every problem under the book. We tried to work with a dealership on it. We told Omni day one, do not let them cash that check, because the dealership kind of Rochambeaued us outside in the parking lot at closing, and they kept the check inside after, we looked at the truck, gave it the final once over. And I'm like, this isn't going to work. This truck isn't running. And it's a $50,000, $40,000 truck. We got on the phone with Caleb. We had a verbal back and forth. Hey, this has happened again. Once again, you're telling us it's 110% through your vetting process, but this truck is clearly not what it is that they're selling is not a good product, right? So Caleb says, okay, good deal. Work with them on it, see what you can do. I'll take care of things from my end. In the meantime, I said, all right, cool. I tried to work with him on it as far as if they can get it fixed and they can get things going, then I'll sign the title work and we'll move forward on the purchase. They did not do that, nor could they, because the truck was in such disrepair that, they were just trying to off a truck that was garbage essentially onto somebody. Now, if you look at the work, they sold it back to themselves. They sold it back to themselves for $25,000 after they threatened to impound it from us and all this other stuff. I said, it's not my truck. I never signed the purchase agreement, the title work. I didn't sign that. And the reason I didn't was because we didn't want to purchase the truck. Omni was 100%, this was made known to them day one. And then we worked with them on it for a couple of weeks. They kept stonewalling us as far as what was going on with the money. And the eventuality of it was that they sat with their own truck down there for a pretty extended period of time, to the point that Omni, going back and forth with them, basically told us, well, it's going to go up to auction. And I said, well, how are they going to auction their own truck to someone else? That doesn't make sense to me, because they own it. And then they auctioned it to themselves at Royal RV for half of what they were going to make us pay for it. Mind you, this is a truck that's got rust in the headrests from Houston. I come to find out it's a service truck from Houston, Texas. They lied on the Carfax. It's just, none of this was on the level, but Omni's trying to act like, because a year has passed since the beginning of this, that they didn't do anything unscrupulous. And again, this is the fourth vehicle that we've went to purchase through Omni that we went to pick up. And one of them was a brand new 2024 Dodge Ram out of North Carolina that had a diesel that had the entire catalytic converter set just ruined in it. Now, luckily, Dodge worked with the situation good. And because I did buy that truck, straight up purchased it. And then the cats were bad. So then they took it back. They refunded the money. We have a history of this, because I'm not a guy who's going to go out and spend 50 grand on a truck or get myself locked into payments for something that isn't going to work. These vehicles, we use them for my business, which isn't doing great right now as it is. But this entire situation has really kind of put me on my butt this last year, not having a second vehicle. all but being like harassed every time I go into Omni to try to make this truck payment. It's a big embarrassing show in front of people in our small town. They've all but debanked me. They won't cash my checks. They won't, and they've acted like I've done something wrong. When this thing was talked about from day one, when that check went through, I said, hey, this is no good. This deal isn't going to work. I told them this is a flood truck. We went back and forth with the dealership on it, tried to work with him like Omni said. In the end, it was an untenable situation, and it just wasn't going to work out because A, they wouldn't fix the truck, and B, the value of the truck wasn't what they were trying to sell it for. The third time we drove it, we never had this truck at our house for more than an hour or two at a time, mind you. We did have it one weekend because we couldn't return it. The very first weekend we got it, we were like, hey, this isn't going to work. And they're like, all right, well, you got to bring it back. I'm like, all right, well, when? And then it was like a Monday thing. It's the only time we even ever had the truck. This was like an extended test drive. So by the time they got it back, it was, well, we're going to impound it if you don't want to come and get it. And then they sold themselves for $25,000. That's where we're at with it, Your Honor. I never made a single payment on the loan because I didn't want the loan. I made that abundantly clear. And this is where we're at with the thing a year later or whatever. And now the vehicle itself, I would love for a third party, someone to check it out, because it is absolutely 100% a flood truck from Houston, Texas. And they've got multiple trucks just like this down there on their lot. And then we've got Omni telling us that it's 100% great truck, meets the standard.
Let me stop. You haven't stopped to take a breath. You've been talking nonstop for about 17 minutes. While you were talking, I think the record was still on. I've got everybody back now. So let me ask you a question. Where's Omni's $50,000?
Is with the dealership that they were supposed to recoup it from. We went back and forth for a week and a half about this money and the fact that the check was not to be cashed in the first place.
They don't have an agreement with the dealership. They have an agreement with you. You got hooked up with some crooked sale and you agreed with the bank to borrow $50,000.
No, sir. In reverse.
So, stop.
It was in reverse.
It's my turn to talk. You borrowed all this money and Omni Credit Union paid it to these people you bought the truck from. So they've got $50,000 of Omni Credit Union's money. Then they repossessed this and sold it. And what Omni is suing you for is the difference. They're only the lender. This isn't an auto finance where you buy the car there. It's a bank. You went to the credit union as you have in the past and borrowed money to buy a vehicle. They don't have any. Will you stop interrupting me? I'll let you speak. I let you speak for a long time.
Yes, sir.
They didn't have anything to do with what kind of truck you bought or who you brought it from. You had a history of borrowing money from them, so they agreed to loan you this money. So you took their money and gave it to this person you got the truck from, which apparently was. All right, what happened?
They were given a check. They were told not to cash the check. They agreed not to cash the check until terms were sorted out with the truck.
Who's they?
The dealership and Omni as well. And the dealership.
I know you don't.
Everything was put on hold.
Check, it's a negotiable instrument. You don't buy a truck and say, hey, don't cash this check. Once Omni gives you the check, they lose control of it.
No, they can decide whether or not to allow the dealership to cash it. And they had the opportunity to not let them cash it. We had the discussion. That was what was agreed.
How is that?
That's happened several times, sir. Several different times this has happened with vehicles with them because they do a vettership. They have to vet the vehicle in order to make sure that their purchase is good because that vehicle is now collateral for the monies. If the collateral doesn't stand against the monies that they've lended, then they won't lend the money. So they're not going to give me 50 grand for a vehicle that doesn't work.
What's your authority for that? That's just the way you think it is?
Questions, no, sir. It's what we all agreed upon.
The law to say they have the authority to do this, or this is just the way you believe it is?
we all agreed upon that, and I've seen that happen before with the situation. So I haven't not been in a situation like this with them before, and the way that they acted before was on the level, honestly, with scruples. This time they did not.
They who?
Caleb at Omni, and also Christine at Omni, or who I was dealing with.
All right, you're putting all this on Omni. Omni didn't have anything to. You selected this truck, found it, asked to borrow this large amount of money to apply to this truck. Now you at one point alleged you didn't sign it, but you clearly
I did never sign any title work. No, I didn't. I did never sign any title work. They never repossessed the vehicle because it was always in their name. It was always in Royal RV's name. I never owned the vehicle, Your Honor. I never signed title work to the state of Michigan. I did not purchase the vehicle.
I don't know about the vehicle. You signed a loan to buy the vehicle.
Right, and it's a collateral loan.
Yes. All right.
Right, and so without sufficient collateral, the monies can't be allocated toward the debt.
All right, according to what? According to who?
According to fiduciary laws and the FDC, like that's how that works. If you get a vehicle loan,
authority for that?
I could, not on the phone, not in front of me, but I could certainly look it up for you. If the bank, so, and here's the other problem is the loan for the truck itself is actually over its end, just like the truck that I'm sitting in now. They've given me more money toward a truck that wasn't worth the value of the truck. This is something that Dana Nessel is dealing with right now on a state level. And Omni has done this to me 3 different times where I didn't know until after the fact. But after the fact, I find out that they're giving loan amounts of money out for vehicles that aren't even worth the amount of money that they're loaning for them.
Well, none of this is your fault. You find some fly-by-night somebody to buy this 2019 F-20 Super Duty. You don't do your due diligence. You asked to borrow $41,000. And
sir, I did. I did my due diligence.
Stop. It's like you've got no responsibility in this. None of this is your fault. You went to Omni and asked to borrow $41,000.
Yes, sir.
They gave you a check for $41,000, and that money was given to this seller of this truck. So they're out $41,000 less what they sold the truck for after it was repossessed. So, Ms. Escamilla, what's your position regarding this?
My position is, again, Omni is not in the business of vetting vehicles. When someone comes and asks for a loan, they're in the business of making loans. And they had a history with the borrowers. We did submit exhibits to the court as well as to the defendants that show that there is a title in their name, that shows they signed a purchase agreement, that show that they provided a insurance.
There's no title in our name. It's a lie.
And so they took out insurance so that they could drive the vehicle off the lot. So I dispute that they're saying that they never purchased the vehicle. I think it's unfortunate what happened to them, but the dispute really should be with the dealership. We also attached the documents that show that there was the repo cast. Omni, the reason it was sold back to the dealer is that Omni determined that was they could get the most money for the defendants to mitigate the damages rather than sell it at the auction. I think that the auctioneer RepoCast, who does this frequently, knew the values. But again, I feel for the defendants. This is unfortunate, but this is really a dispute with the dealership. Omni didn't sell them the car. Omni gave them the money, and they've been damaged and lost money from this.
Okay.
Looking for the title. Yeah, there are 2 $25,000 checks.
Your Honor, the truck was never. Your Honor, the truck was never titled in our name. That's a fallacy, and it was never repossessed. Repossession is a legal term, and it was never repossessed from us because it was never in our name.
Yeah, here's a copy of the title. Vehicle number, ID number 2019 Ford F-250, titled in the name of Chelsea Nicole Lafferty and Kevin Carl Wilson.
No, sir, I never signed that title. They printed that. That was something they printed. That's nothing we signed. We did not register it in the state of Michigan. We did not purchase the vehicle. And this was all made abundantly clear within the first 3 days of this going on.
Yeah, you purchased insurance on this vehicle, and so you have to own it to buy insurance on it.
No, sir, you don't. You don't at all. We were told that we had to get insurance in order to test drive the vehicle. We did that. We held an insurance policy with State Farm at the time. That's all there is to it. If it was my vehicle when it took me off the road, I would have filed a claim. I didn't do that because I was told by my insurance company that was not necessary because we didn't own the vehicle.
That's hearsay.
Okay, I have proof of that. We can talk to the insurance company, but at the end of the day, my name is not on that title, nor would it ever be because it's a flood truck. I never titled that truck, therefore I never owned it. It was never repossessed because it was never in my possession.
All right. Ms. Escamilla, what's your take regarding the title?
Well, I mean, there's clearly a title that's been filed with the Secretary of State. Our clients don't
No, there
file
hasn't.
titles.
No, there has not. There has not. That is a straight up lie.
Mr. Wilson?
Yes,
you're
sir.
very disrespectful. This is a court proceeding. We're not sitting around the kitchen table. She's an attorney. You're not. If there was an attorney here, they wouldn't do what you're doing. And they wouldn't let you do it either. They wouldn't let you blurt things out and call people liars. There is a title in this matter where the vehicle is titled to you. There's proof that the vehicle was insured to you. And there's proof that you and your wife signed a loan agreement to purchase this vehicle. They are the people that lent you the money to buy the vehicle. They don't go out and inspect your vehicle to make sure it's worth that. If it isn't,
yes, sir,
that's on you. Then it gets repossessed and sold. They sold it back to the company because they made more money doing that than they would by selling it at auction. You'd be shocked at how low. I'm going to mute your microphone, Mr. Wilson. You don't have the respect to not speak when I'm speaking. And I'm going to tell you that you owe they sent you all of this documentation. They sent you the loan agreement. They sent you the notice that the vehicle was going to be repossessed and sold. They sent you a copy of the title to this vehicle. And they sent you the motion for summary disposition and explained what it was. You owe $19,474.44 plus costs, which is $160 in filing fee, service fee in the amount of $720, a motion fee in the amount of $200, and the statutory attorney fee of $75. The total is $19,806.64. You did electronically sign this loan agreement. They wouldn't have given you two $25,000 checks if you hadn't actually signed the agreement. They're the lender. If the vehicle was junky or dysfunctional or flood damaged, you have a cause of action against the people you bought the truck from, but not against the people that lent you money to buy the truck. Ms. Escamilla, I thought I had an order in here, but I can't seem to put my finger on it.
We did submit an order, but I can resend it to, the
If you
email.
did, I've got it. Let me find it. Mr. Wilson, I don't have to like this, and you've got some impressions about how things are supposed to work, but they're not correct. You cite authority as though it is authority. She cites the authority, which is actually the authority in her brief. Plus, you didn't respond to the brief. You just wrote me a letter that says, I didn't buy this truck. When clearly you did. You can appeal this, but right now you're paying for a dead horse. A truck you no longer have. You may have a cause of action, as I said, against the company that lent you the money. The court cost and the damages are $19,806.64. They're in the business of doing this. They didn't just wake up one day and decide they were going to do this. She did a very accurate job, just a minute, of providing the brief, the legal authority, the evidence that supports their claim. And you have a 2-line answer that says, I didn't buy this truck. So go ahead and unmute your microphone and I'll let you get a final word in here. You can unmute it at your end. Let me try. Whoops.
To appeal it, and I'll hire an attorney, and we'll see you back here when we come back here. That's the only thing I have to say.
All right, thank you. You're good to go.
Can you show me that title with my name on it that I signed?
She sent it to you.
No, she
It's
didn't,
in the
because it doesn't
pleadings.
exist. If that happened, then they forged my signature, because I never signed that title. It never got taken to the state of Michigan. I did not sign that paperwork, and neither did Chelsea. And we have emails to confirm back and forth with Omni,
well, thank
because
you. You can bring that up
they
on
tried
your
to-
appeal. You could go to the Secretary of State and see where, I don't know where the title is now. I don't know if I got sent back, but he has the same copy of the title that was filed as an exhibit. Obviously, I wouldn't be very happy either, paying $19,000 for a truck that I no longer have. And maybe this was a bad deal all the way around, but it wasn't Omni Credit Union's bad deal, it was his. So according to him, you guys should just eat the $19,000. At any rate, Ms. Escamilla, I didn't give you a chance to say very much, but you pled this matter well. The pleadings speak for themselves. You've got all the exhibits, affidavits, documentation, the loan agreement. He can appeal the motion and hire a lawyer and see if he can get any traction, but I think my ruling here is accurate. All right, that was not much fun, but my ruling stands. And we'll send a copy of that, and then they can decide what they want to do. But this is a very unpleasant collection case, I suspect.
Thank you, Your Honor.
All right, I'll see you next time. Thank you.
All right, thank you.
All right, so we've got Copper Bay here.
Good morning, Your Honor.
Good morning, Mr. Boleyn and Ms. Hill. I received a conditional order of dismissal in your case, and I signed it. So thanks for checking in. It is 10:30. The defendant hasn't appeared. So apparently you worked out an agreement with this tenant. Is that correct?
That is correct. We worked out an agreement. They signed it and sent it over late yesterday. I told them that we would be sending it to the court and they should still show up at the hearing unless we heard otherwise. I did not tell them otherwise, so I'm surprised they're not here, but in any event, I think that we do have this agreement and we're, still comfortable with that being entered by the court if the court would.
All right, I've entered it. As you heard there, I just went through a contentious summary disposition case. But I had 15 cases scheduled this morning and 13 of them were resolved, including yours. So thank you for joining this morning. Hope you have a good day. Our power went out for a minute while I was in the middle of the last hearing. So let's hope we don't have any more of that. There's real windy here. All right, well, I'll see you again unless everybody continues to pay their rent like they're supposed to, in which case I will see you again.
Thank you very much.
Thank you.
Bye.
Bye. All right, our next matter is Enchanted Glen at 11. Our block 14 case at 1040 was also dismissed. So those defendants have not appeared. I'm gonna stop the live stream and stop the record, and we'll be back.
Maybe. That's probably not it. All right. What is plaintiff's claim in this case?
With cost, Your Honor, $3,099.38.
All right. And Ms. Richter, how are you intending on getting that paid?
I reached out to the Housing Bureau for Seniors for help.
Okay. All right. Did they tell you anything or?
No, not yet.
Okay. Have you reached out to anyone else for help or assistance?
Well, Hawk said that I made $100 too much a year.
A year. Okay. Well, I guess you got to have a cutoff somewhere, right?
I guess, yeah.
Okay. So you make too much for Hawk. Did you apply for an SCR at all?
No.
No? Okay, so here's what I'm going to do.
No, because Hawk referred me to the Housing Bureau for Seniors.
Gotcha. Okay. So what I'm going to do is that there's a form in your packet, the rental assistance form. I've made a note here. Just fill that form out, get it to the court by Wednesday, and just put down at the bottom that you called Hawk. They referred you to the Housing Bureau for Seniors, okay?
Okay. And I'm sorry, can I get that total again?
It's $3,099.38.
Okay.
Okay?
Okay,
so
thank
basically
you.
3,100, okay?
All right.
And so I'll adjourn this out, Ms. Richter, to March 20th, 2026 at 1 p.m. That's an in-person hearing, so you'll need to come down to the courthouse. All right?
Okay.
And then you can give us the information on the Housing Bureau for Seniors and what's happened there, and let's see where we can go with this. All right?
Okay, thank you.
Thank you, Ms. Richter.
Bye-bye.
Bye-bye. Northville Crossing versus Suzanne Hovnik.
And Your Honor, there was an Ashley Glidden who was present. She is the personal representative for the estate of Suzanne Hovnik. This account is paid in full, Your Honor. I did correspond with Ms. Glidden via email this morning and let her know the same. And so we'd like to dismiss this matter without prejudice.
All right, this case is dismissed. That's without. Sorry.
I just stayed on to say good morning, Judge Simpson, and have a good day.
Okay, she stayed on to tell me that. That's made my day. Thank you so very much.
Thank you. Have a good day. Thank you.
All right.
Bye-bye.
Bye. Northville Crossing versus Norman Tucker.
Hello, sir.
There he is. Okay. What is plaintiff's claim?
Cost, Your Honor, $2,086.11.
All right. Sir, how are you intending on getting that paid?
Well, this is my dilemma right now is I just lost my job in December. I lost $5,000 a month, and I'm living on Social Security right now. And with the past 2 months, I've been trying to play catch up and keep minimum payments. I saw a lawyer yesterday to file Chapter 7, and he told me yesterday, don't pay any more bills, the ones I plan on getting rid of. And so the next opportunity I'm going to have, because unfortunately you get one check a month, is on April the 8th, I will pay this amount. And then in the following month, I'll pay for April and May. Then I'll be up to date.
All right, sir, has the Chapter 7 been filed?
No, I'm still waiting on, I need my income tax to come back. He needs that. I'm waiting on my ex-employer to send me 6 months of my pay stubs from last year, just to prove
Okay, so that's not been filed. All right,
No.
here's what I'm gonna do. I'm going to adjourn this out to the 20th, 2026 at 1 p.m. That's an in-person hearing. You might want to have your attorney, if they're not gonna file right at that moment, contact the attorney for the plaintiff. So they can discuss it, but I'm gonna just move it along because I don't have a bankruptcy stay at this point in time. So I'm just gonna go to next week at 1 o'clock. All right, sir?
Okay, that's March 20th, what state?
March 20th at 1 o'clock.
Okay, that's in court.
And that's an in-person hearing at the courthouse. All right, sir?
I appreciate it. Thank you.
All right, thank you.
All right, bye-bye.
Court calls the case of Northville Crossing versus Jeremy Walker. And Jessica Webster.
Here, sir.
Oh, there they are. All right. What is plaintiff's claim?
With cost, Your Honor, $905.50.
$905.50.
Yes.
All right. And folks, how are you intending on getting that paid?
Well, two things I'd like to talk about, sir. The first thing is the demand for possession, non-payment for rent, dated for 2/6/2026. I never received this letter.
Okay.
The second thing is, as far as my knowledge, I should be paid up in full. I paid on 2/20, $1,183.05. On 3/10, I delivered a certified cashier check for $899.50. According to
you did that this week?
Correct, sir. That was on 3/10.
Do you see that on yours?
I do not, Your Honor, and so I don't have an objection if the court wants to adjourn this. I'll verify with the client, and we can dismiss if appropriate. If for some reason my client says otherwise, Your Honor, I have a phone number ending in 5083. Is that a good phone number for either Ms. Webster or Mr. Walker?
Yes, that's absolutely correct.
I can
Okay.
verify
So here's
with
what.
you if that's the case.
Okay, here's what I'll do. I'll adjourn this to March 20th, 2026, 1 p.m. That is an in-person hearing, but if everything's paid in full, you don't need to appear and the case will be dismissed. They're gonna, and I think what Ms. Dornbush is gonna do is gonna verify that with her client and probably give you guys a call. All right?
Thank you very much.
Thank you very much.
All right, thank you. Northville Crossing versus Timothy Wright and Sherry Mullins. Oh, Ms. Mullins, I see you. I can't hear you. I know you're trying.
There we go.
There you go.
There we go.
All right.
Thank you, Your Honor.
Not a problem. Good morning.
Good morning.
All right. And what is plaintiff's claim in this case?
With costs, Your Honor, $1,663.40.
All right. And Ms. Mullins, how are you gonna get that paid?
Well, Your Honor, she probably doesn't know because we dropped it off 2 days ago. The amount that was on the paperwork was $440. I spoke with Bobby and I gave her a money order for $500. And then we were going to pay the balance between this Friday and next Friday.
Okay. All right. Here's what I'll do then. They probably don't have that. So I'm going to adjourn this out 1 week to the 20th, 2026 at 1 p.m.
Okay.
As you heard me tell people, that's an in-person hearing. But if
Right.
everything is paid in full by that time, then you don't need to appear and they're going to dismiss the case.
Okay, good. Thank you so
Okay.
much, Your Honor. Yes. Have a blessed day.
You do the same. Thank you. That's it for Ms. Dornbush?
Well,
Really?
that's it for the 8:30 docket, Your Honor. I'll be
Yeah.
back with you.
All righty. Thank you. Group 5 Management versus Burnett Turbington.
Morning, Your Honor. Robert Weiss appearing on behalf of Group 5.
Ms. Turbington? I see. Yeah. Ms. Turbington, if the iPad is you, wave your hand. I don't know if she can hear me. Ms. Turbington, is that you? I don't think she can hear me.
I assumed it was her because she started touching her eye.
Yeah, no, and she's unmuted at this point, but.
I'm the property manager. I'm Cosetta. I'm not.
Oh, you're the property. Okay. You guys are going to have to label yourself. I'm not sure why they're in the Zoom. Is Ms. Turbington here?
Garbage can is tipped over and shit's gone down the road.
Okay. All right. Mr. Weiss, Ms. Turbington is not here. Would you like to proceed, sir?
I would, Your Honor. I'm raising my.
All right. All right. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do, Your Honor. The amount owing, including court costs on this, is $1,353. Request a judgment for possession. Was there personal service, Your Honor?
There was not.
Okay. Judgment for possession, writ to issue on or after the 23rd.
All right. Judgment to the plaintiff. That's by default for possession. Redemption amount in the amount requested with the writ issue in 10 days. Group 5 Management versus Winston Johnson. Winston Johnson, they are not checked in. You may proceed, sir.
Thank you. The amount owing in this case, Your Honor, is $1,602.42, including court costs, judgment for possession. Was there personal service on that one?
There was not.
Okay. Judgment for possession only, writ to issue on or after the 23rd. I'll fax them over to the court.
All right. Judgment to the plaintiff by default for possession.
I think that's it for me.
That is, sir. Good to see you.
You too. Have a good weekend, Your Honor.
Have a good one. Bye-bye.
All right. Thank you. Douglas Barton versus George Henderson. Douglas Barton, George Henderson.
Hey, my work should be over by 10:15. All right. They ain't called me yet.
Did you log in?
Yeah, I'm logged in. I'm waiting for them to call my name.
Yeah.
Okay, you wait. Thank you. I don't know. I'm just looking for these people. Douglas Barton, George Henderson. I have no response.
I'm here.
Okay, what's your name?
This is Douglas Barnes Sr.
Got it. All right. George Henderson? Are you here? No? All right. They're not here. If you could, Mr. Barton, if you can raise your right hand.
Sure.
Do you swear or affirm testimony you're about to give to this court will be the truth and whole truth and nothing but the truth, so help you God?
I do.
All right. And what is your claim in this case? How much do you say they owe?
His back rent is $1,500.
That's what he owes now?
Yes.
All right. And I've got cost in a total amount of $68. So I'm going to grant a judgment by default for possession, $1,500 plus your cost of $68 for a total amount of $1,568 that would need to be paid by March 23rd, or an order of eviction could issue. All right. So I've issued the judgment. You'll need to get down to the court or fill out a judgment and get it to the court for my signature. Okay, sir?
Yes, sir.
All right. Thank you.
You're welcome. Thank you.
All right. That ends my 8:30 block. We've got to set up. I'm assuming all of these other people are here for the 10. Okay, then I'm going to step off. We're going to run our video, then I'll come back and we'll run the 10 o'clock block. Court's in recess.
Good morning, Mr. Roberts. I haven't seen you in a while.
Morning, Judge.
I think we've got everybody we need here. A little early, but let's call this case. This is file number 26. Oh, wait, we don't have the plaintiff's lawyer yet. I advised manager Kim that we have had some power issues. She's advised they've lost power in Colon. And twice this morning, the power has clicked out here at the courthouse. So let's hope we can get through this hearing. It looks like the lights are blinking again.
Oh my God. The nasty wind out there.
Good morning, Mr. Popovits.
Good morning, Your Honor.
How's the weather in Traverse City?
Snowy and horrible. Thankful I only live about 5 minutes from my office.
Well, we don't have snow, but it's real windy here and stormy.
Okay.
I have a friend who sent me some pictures from Cadillac, and they were still skiing on Wednesday night. So you probably got even more up there.
Yeah, we're getting.
I don't know.
We had lost most of our snow, but it came back overnight pretty quickly. So.
Well, this is why we like living in Michigan.
Absolutely.
I lost Miss Cleveland. This is file number 26129 LT. It's entitled Chanted Glen versus William Roche and Mary Cleveland. Miss Cleveland was here with us and I lost her. But she is in Colon, so I don't know whether she has power. She was here. Mr. Donald Roberts is here from Legal Aid. Meg Bauer had been handling this case and has filed an appearance on behalf of the defendants. Mr. Roberts, are you taking the case over or just covering for today?
Just covering for today. Ms. Bauer is ill, very ill.
Sorry to hear that.
Yeah, so I always hate it when other people say this, and I feel bad saying myself. I got it yesterday, late yesterday afternoon, and I've done my best to acquaint myself with the facts.
All right, well, thank you. We've lost the defendant. There is a terrible flu that's been going around. I had a case earlier this morning where the attorney was ill and the matter had to be reset. So hopefully she doesn't have that. I don't want to do too much without the defendant because I want to do it all over again. Kim Snow, the manager there, are you at Enchanted Glen Apartments right now?
I am, Your Honor.
And the whole complex is out of power?
Yes. She looked like she might have been on her cell phone. I think that's all they have is their cell phone, so she might be able to get back on.
Is it just Enchanted Glen or is it the whole village of Colon?
That I couldn't tell you.
You're just wherever you are. I have no problem.
It might be the whole area because I just got a text message on the work phone stating that, well, it just says in our area at 468 South Baroque Road. So it might just be here.
Well, I heard it was the whole village, but
Okay.
Well, it's always something. Let's say what we can say. This matter was filed. The defendant did not appear and the court entered a default judgment. Plaintiff filed a motion to set aside the default. I waived the filing fee. Meg Bauer appeared on the defendant's behalf. Mr. Popovich was very gracious. We set aside the default and I advised the defendant of her rights and we set the matter for a second hearing today. So, Mr. Popovich, what does the plaintiff claim as the current arrearage?
With me, Your Honor, I'll pull the ledger up. I just sent that. The current arrearage is $4,362. That's through March. We did, following the hearing, I have forwarded to Meg. Now, I'm not sure if she's looked at it, if she's been sick, and I certainly understand that, but I did give to her the copy of the tenant file with a little bit of an explanation because those documents had been made available to Ms. Cleveland through Ms. Shaw, and those were sent, though, by email to Ms. Bauer. We also sent a little bit of an information. These cases, these non-payment cases, always tend to become more complicated than just essentially the amount of rent that's due and owing. There is always usually some argument or some discussion point as to recertifications that should or shouldn't have taken place and whether or not the rent values are correct as set forth on the property management's ledger. I did also give Ms. Bauer a breakdown of my client's notes as to previous communications in that regard. And I've not heard back, but it's only been a short time. I did get her appearance and certainly was producing this information to her before I even received the written appearance because of her representations at court and my history with Ms. Bauer. I knew she wouldn't be appearing without formalizing her appearance. I will say one last thing. There has been also observances, and there was a representation by Ms. Cleveland at the last hearing that she was moving. So to that end, and I think I emailed Ms. Bauer about that, if her client is moving, this becomes a lot less difficult conversation point.
Well, she is trying to join. What are the court costs in this case?
$313.45.
So the total plaintiff claims is due is $4,362 plus $313.45.
Yes.
which is $4,675.45. Miss Cleveland flashed across the screen for a moment, and I've lost her again. And Mr. Roberts, I appreciate your appearing here. Mr. Roberts got many, many years of legal experience also in this particular area. But it's always a little disconcerting when you get the file the night before the hearing and try to get up to speed on it. And then your client doesn't show up because they can't log in. Meg raised a bunch of issues, but no answer has been filed by the defendant. And as Mr. Popovich indicated, if they're moving, this matter is going to be a lot less contentious than it could be. Mr. Roberts, what do you know so far from your looking at the file?
I believe I have the 94 some odd pages that Mr. Popovich forwarded, and I've had a chance, I frankly skimmed through them. My take on the thing is apparently there was some, and I believe he hit the nail on the head. There was some confusion, misunderstanding, whatever, between when they would start to pay what would be market rate, the $1,083 and so, and then when a subsidy was supposed to or has kicked in. That's pretty much it. My understanding is at this point the rent's supposed to be, after the first of the year, the rent was supposed to be $212 a month. The client's portion of the rent was to be $212 a month. But I don't know, again, I'm going on what the documentation I've seen, what Mrs. Cleveland, and I haven't had a chance to really talk to her in person. So, but what she has indicated to us in her writings, and that there's some confusion as to what the rent was supposed to be for December. But again, starting the first of the year, there was supposed to be some sort of subsidy. Not sure who the agent was. I mean, it was through Keystone, but I think this is a LIHTC property, so I'm not, sorry,
Well,
I don't know
Snow,
exactly.
what is the current rent according to Enchanted Glen?
In January, it would have been the one, it went up. And Your Honor, I cannot see in my office to grab their file to
Oh
find
yeah,
out.
you don't have a computer.
But what had happened was
I was told the rent was $1,083.
in December, correct.
Okay.
And they needed to come into my office to recertify. He added, was brought to my attention in November-ish that he had income that was never reported to the office. So I sent them a letter stating, as in Jeffrey. And I sent them a letter and asked them to come to my office.
Who's Jeffrey?
Her other half that lives there.
William Roche?
William, I'm sorry. Yes, William.
All right.
I have two people that are in the same situation. They were told to come to the office. They did start to fill out their recertification papers, but they've never finished doing their recertification papers because of all this. So in January, we always have a rent increase in January. So their rent would have went up. Yes, they would have gotten their recertification done. Yes, their rent went down, but they never came in to recertify. I don't know where they got the $212. That was never in their file. Keystone pays max rent no matter what. They won't pay if you have rental assistance. So they pay the max amount of rent. So they would never have gotten rental assistance with Keystone.
Say that again.
Keystone pays the max rent. They won't help people move in somewhere if they get rental assistance, because that's just not how they work. So Keystone paid the $1,083 for them while they lived here up until I think November was the last that Keystone was to pay, which would have meant they would have had to have paid that rent in November and then recertify, and it would have probably went down, but they've never came in to finish recertification with me. And then they never reported his income, the Williams income. And that's supposed to be reported within 30 days. And I found out about it just about the time that Keystone was getting done with paying their rent. So I don't know where the $212 came from, because I don't make that call. I would not have had a clue. There's nothing in their file that I've saw that
Yes,
said
Keystone
$212.
doesn't pay rent for people that have subsidized rent. They figure they already got a sufficient break, and so they only pay market rent. And now they're paying $1,000 a month, and we've got a lot of these. The development here in Centerville, they'll get people in and pay rent for several months, and then the subsidy runs out, and then the people can't pay the rent. So right now, according to the manager, the defendants have not recertified. Rent stays what it is.
She can't call or Zoom in, but there's her phone number.
All right. She has been able to Zoom in. I'm going to call her. You have to be adaptable.
Hello?
Hi, is this Mary Cleveland?
Yes.
This is Judge Middleton. Is Mr. Roche with you?
Yes, he is.
All right.
I can't get into Zoom. My electric's out, and I need the electric for the phone I can use Zoom on.
All right. Well, you were there briefly, and then you went on. We are aware the electric is out. Your manager is out also. So let me tell you where we are. Your manager, Kim, is here. The attorney for the apartment complex, Mr. Popovitz, is here. And Donald Roberts is here from legal aid because Meg Bauer is ill.
Right.
So here's what.
I haven't even had a chance to consult with the lawyers.
All right. Well, here's what we've discussed. The plaintiff claims that your rent through March is $4,362. And that your court costs are $313.45. And they claim that you owe through March $4,675.45. Mr. Popovitz, you agree with that?
Yes.
And Mr. Roberts, you agree that's what we discussed while the defendant was outside?
That's what we discussed.
All right. Now, them saying that's accurate, that's just what they claim. Kim represents that your subsidy from Keystone ran out in February and that you were supposed to recertify, and you and William never finished the recertification. Ms. Snow also, all right, she also represented that William has income that was not reported and not part of the certification. Now,
that's also not true.
All right. Does William have income?
Yes, he gets $990 on SSI, and he told her about it the day he got the letter.
I do, Your Honor, have copies of all that stuff.
All right,
They
just a
never came over.
minute, just a minute. I didn't ask you anything.
Okay.
Now,
No, I thought the phone went.
you represented last time that you may be moving. Are you planning to? All right, tell us about that.
Yes, we are, but this whole thing has been a nightmare. We can't find a place to go, and Keystone says that they can't help us anymore, and that Neighborhood Inc. can't help us. Hello?
I'm still here.
No.
All right. So we don't exactly know how much you owe. People tell me this all the time. I would move if I had somewhere to move to. This apartment was at market rent which was $1,083 a month. And Keystone paid your rent for several months to the tune of maybe $8,000 or $10,000. Then after November, that subsidy ran out. And I don't know exactly what the rent would be because according to the manager, you've never recertified.
No, we did. We went over and signed papers for the subsidy, both of us.
Well,
And
her contention is it was never completed. So I don't know the answer to that. So,
well, she told us that our rent was going to be $212 for January, starting in January. So
now she has a different take on that. I was told it was going to be $224. So did you pay any month in January, February, or March?
no, I have not. Because there's no way I can pay full rent. Bill has cancer. He has to have things for his treatment.
But you didn't pay even $212 or $224, any amount.
Who didn't?
Did you pay any? When she said it was going to be $212,
No,
you
I
pay
didn't.
$212?
I didn't, because she told us we were good until January, and then that was on the 12th. She told me that. On the 10th, she told Bill that, and on the 15th, she gave us the demand for possession.
All right. So nothing has been paid since apparently just November.
No. I've been trying to get this straightened out.
All right, and Keystone is done, and Neighborhood Inc. advised they weren't able to help.
Eric at Keystone told me that we used up our time allotment, which I didn't have any idea there was a time allotment. But anyway, he told me that we weren't eligible for help for Keystone or Neighborhood Inc.
All right. Yes, they don't just continue to pay market rent indefinitely. They pay for several months, hoping that.
We didn't expect it.
All right, that you were either.
Definitely, but he did tell us it would be up to 18 months.
Well,
so and when it abruptly stopped, he sent the paperwork on October 31st, and we never got it on our door until the middle of the month, which gave us 2 weeks to come up with full rent.
All right.
Christmas time.
So what do you want me to do? I'll defer to you in a minute, Mr. Roberts.
All I want is just that if we can get the 10 days and we'll be out. We'll have to be out. We've had to rent a U-Haul truck to, and get a storage thing, but we're not done yet. I mean, it's just him and I. So.
All right. So you are planning to move. Now, this was adjourned a couple of times, and I had told you this. First, there was a default. He didn't show up, some confusion or technical problems. So some time passed. I set it aside. Then we set another hearing. So more time has passed than would normally pass. So you're right. What I told you is you have 10 days from today to move, or you would be subject to being evicted. Now, if you're planning to move anyway, the dollar amount is not crucial because I'm not entering a money judgment. I would be entering a possession judgment. So let's say I just pulled a number out of the air and said you owe $10,000 if you wish to stay there or you have to move. So you move. Then in the unlikely event that the plaintiff sues you for $10,000, they would have to prove that you actually owed it.
Well, my worry too my biggest worry is that if we get an eviction on our record, we won't be able to get into subsidized, and we cannot make it without subsidized.
That is very true. And Mr. Roberts and Ms. Bauer confront that situation every day. If you get evicted, you have an eviction on your record, it can make it very difficult for you to get into subsidized housing. Enchanted Glen says you haven't paid your rent in December, January, February, or March. We have a waiting
There was
list.
a discrepancy in what she told us.
All right, well,
That's why.
all right, well, irregardless, no rent has been paid.
Right.
They claim it's $1,000, you claim it's 212, nothing has been paid. And so we were trying to figure out how much do you owe to tell you this is how much you owe. You have to pay it by this date. There's a dispute as to whether you recertified or not. She says you don't, you said you did. I don't know that you signed it. Did you sign a new lease that told you the rent was $212?
No, he told us personally.
He who?
Both of us.
He.
Kim.
She.
Pardon me?
Kim.
Kim told us both personally.
All right.
We were paid until January 1st, and that then the rent would be $212 a
All
month.
right. Well, that doesn't just happen magically. You have to sign a lease or renew a lease.
We signed papers for it.
All right, and that's where the fundamental dispute is. So, Mr. Roberts and Mr. Popovich, thank you for your indulgence here. You've been listening to this exchange. Mr. Roberts, what's your take here?
Well, I would think that that seems to be the fundamental question is there's contrary testimony between the parties, proposed testimony, because no one was sworn in. So, I mean, I think we probably just need an evidentiary hearing, and if there was a certification or if there isn't, and that would determine the amount of rent that's due. And again, there has not been an answer filed, which I do apologize for, but under the circumstances, a bit of a challenge with some other issues that are there. But it seems to be the fundamental issue has to do with whether or not there was a certification or not, and what the amount would be if it was certified. So it did go through.
He said there's a fundamental issue about how much money is due. So let's assume that I make a finding that you owe 5 months at $225 a month. That's about $1,125 to pay through March. I don't know whether you have the ability to pay that. And if you get evicted, this is going to be on your record. My impression is that your rent is going to change. Ms. Snow, when you said they started the recertification, were you aware of William Rocha's Social Security income?
At that point, I was, Your Honor. They've never signed a new lease. They signed the one when they first moved in, but they never signed a new lease. They signed the recertification paper, their application, all the papers that I needed to get them started. They never signed a new lease with me. So there's nothing in writing saying, and I would never have said $212 because I don't make that call. Corporate does. Corporate looks everything over in our compliance department. They go in and they say, okay, this is what their rent's going to be out of based off their income. And with them both
All right,
having
so-
income, there's no
So
way they're
her
going to
version is
pay.
correct. She did sign the recertification papers. What happened to them after she signed them?
She never signed a lease. She just signed the application
All right, well,
process.
okay, we'll get to that in a minute. So she resigned the certification papers. What was the rent going to be determined by corporate after they signed that?
We didn't get that far. That's what I've been trying to say. We didn't get that far.
All right. Why not?
Because they have to sign, before we can do that, I have to send all their paperwork into corporate. And I didn't have
Well, she
everything.
can't sign a lease until she knows how much the monthly rent is going to be.
And I can't send it to corporate to compliance until I had all the information
All
I
right,
needed.
just a minute, Ms. Cleveland, you just wait and I'll give you an opportunity to speak. So you indicated they completed the recertification.
No,
So-
they did not. They
Well,
just
you
did the
just-
application process.
All right, so then what do you do with that?
I get all the information together, send it to corporate, to our compliance department. They indeed turn
Okay.
around and say, is there anything else that we need? I never got
All right.
that far because there was still some other things that I needed from them.
Well, all right, you didn't tell me that. You said they completed the application. So you never sent the application into corporate?
No, because there were still things I needed from them. There's all kinds of stuff we need besides just the application. It's the same stuff they
All right,
needed
well,
when they moved in.
What else did you need?
Well, Your Honor, I can't see my office that well to get their file out to be able to read it. The only lighting I have is from my window. I can get it out and do the best I can using the light
Well-
from my window.
All right, well, so you said they've completed the application.
They
And
needed
this
like,
is the
I did
first I
get,
heard that you, all right, so you needed something more. Did you tell them you needed something more?
they knew that when they came in and when they filled out the application process, they knew I was gonna need both of their letters from Social Security, banking information, any other information. Without looking at their file, I don't know what other information they were gonna need. Those are the main ones right there. I got his letter, but I didn't get everything else that I needed. So I can't turn anything into, it's the same process they went through with Keystone. Exact same process. Once they fill out, it's called the application. I go in, make sure I got everything I need with the application, turn it into our compliance department. They indeed turn around and say, yes, here's their new recertification certificates, which is a paper stating what their income is, how much the rent is going to be. They had rent increase in January, but that wasn't going to affect them because Keystone was going to pay at that point. We didn't know that Keystone was going to cancel their rent in November. They didn't
All right,
have to sign
so-
that paper because it was nothing. It was like $1,100, I think is what the rent went up to for a 2-bedroom.
All right, now. So you needed something more, but right now you can't tell me what it was. Did you tell the
Let me see.
defendants? All
Yes,
right,
I
go ahead.
sent them letters telling them they needed to come into my office.
All right, if you could find that, that would be
Send it with the
helpful.
packet.
As Mr. Roberts indicated, nobody's under oath at this point.
Your Honor, I appreciate the way you're conducting this. I wanted to say just a couple of things. One, I appreciate walking through with Kim. It's one thing to sign the application, but to complete the recertification is a different nuance, and that's something I think that was lost in translation. These folks started the process. My guess is they were under the impression, had the process been completed, their rent would reduce. They obviously, as Ms. Shaw's continuing to communicate and indicate, they did not complete the recertification process. There is a protocol there. It's not handled just by Ms. Shaw. It's handled internally by corporate with compliance once it's sent on. Additionally, in Ms.
All right, well, let me stop you right there for a minute. I understand that. I don't understand were the defendants told, hey, you didn't finish the recertification process, and this is the information we need to finish it. And Ms. Snow is just looking for that.
I understand, and I know that that's the last question that was posed to her. And then as to written communications, one way or the other, advising them of what they needed to clarify what the defendants are communicating to the court as to what they were told. I appreciate Mr. Roberts being here. I know, Your Honor, also, when we agreed last week, we were here at this hearing, and this is sort of as a courtesy to counsel or co-counsel, Ms. Bauer and I talked, we were prepared to appear here today for a status conference. She had just gotten the file.
Well, I blocked out a whole hour for this.
Okay.
Thinking maybe we could make some progress. What this case needs is a conditional order of dismissal. It needs to give the defendants an opportunity to have this matter dismissed without it going on their record. Because even if they don't owe $5,000, they owe quite a bit. And that lower sum could even cause let's just assume for the sake of argument, I accept their figure. and I go with 225 plus costs, that's gonna be about $1,500 due in 10 days. I don't think they can pay that. And then they would still have an eviction on their record.
I agree, Your Honor. If I may pontificate, I'm open to conditional dismissals, certainly for the same reasons that Mr. Roberts and Ms. Bauer fight for them. And my client understands, listen, these folks, I don't think my position is they didn't complete the recertification. They owe market rent. They're not getting help by Keystone. At some level, I think you might be right, Your Honor, that these folks won't be able to pay even the lower amount if you were to make the equitable decision based on the arguments, let's say, because I don't think anybody's been sworn in, so it's not necessarily testimony. The arguments, they can't pay it within 10 days. One thing of interest, though, regardless of any of this, these folks don't tend to be highly collectible tenants after they leave subsidized housing. That's not a disparaging comment. It's just a factual one that possession is king in these cases. If these folks are looking for 10 days out, and if they don't move out within 10 days, then we could file the order of eviction, knowing that the issue of the amount of rent that's due would be dealt with later through a collection process. That may be an opportunity here to resolve without having Your Honor have to make a decision one way or the other. And I say that only because if my client does want to send the matter to collections at a later date, a judgment from Your Honor limiting the amount of rent where it might not have been effectively limited or reduced because of the items that Ms. Shaw is saying doesn't put them in a box, but doesn't really show anyone's hand or force anyone to be obligated to a different argument that they're comfortable after the 10 days. But by giving them 10 days with the dismissal, it gives these tenants 10 days to vacate, and without the dismissal or without the order of eviction or judgment being entered against them. And then Enchanted would send this to collections in the sense of anybody who just vacates their lease with a ledger balance. And I hope I'm not speaking out of turn for Kim, but Kim, this is my sincerity as far as I appreciate what the judge is doing today, because I think he's working to get this resolved rather than continued hearings. If the tenants are representing that they need 10 days to move, we simply agree to a possession. It doesn't restrict them from a future living arrangements with another tenant landlord, and then you're still preserve your rights to go to collection for the full amount due, which is probably no different than, from our perspective, than getting a judgment for an amount they can't pay and then having to send it to collections, whether it be 220 or the 1,080. And what it does is saves us from the chance of the judge deciding that the amount is lower, because then we are restricted as to what can be sent to collections because there's an order from a court that's limiting the amount regardless of our arguments that they didn't complete the recertification process. So with that being said, is there an opportunity potentially, and this would require Ms. Cleveland, I guess, to jump in out of respect to Mr. Roberts, and then I'll defer to Mr. Roberts as well, because I've dealt with Ms. Bauer enough to know she's a competent lawyer with a very strong handle on cases. And I don't know that Mr. Roberts even sits here in his position today ready to agree or allow a decision like that to go through without potentially giving Ms. Bauer another chance at a bite at the apple for a defense. But if that was to resolve it, it would be the way we could move forward today without belaboring these issues of recertification versus not recertification. Or we could simply schedule it for a contested trial and go through this testimony. I'll shut up now because I've talked too much, but I just put those out there as potentials. And I like to look at things from both sides, especially where there's an office involved that I've worked against and will likely work against. Again, they seem to get everybody from Enchanted Glen.
All right, Ms. Cleveland, Mr. Popovich just said a lot of things, and most of it made good sense, and I concur with much of what he said. I don't know how much of it you could hear because your power's out. You're here by telephone.
Yeah, I can't hear any of it.
And so he said a whole bunch of things that you couldn't hear. So we heard it. Mr. Roberts heard it. I discussed something called a conditional order of dismissal. And I told you about that last week. It is a way to resolve the case where it would be dismissed and it would not put an eviction on your record. You have indicated you were trying to move within 10 days. That was going to be difficult. My thought was perhaps there might be some additional leeway from the landlord. They might give you till the end of March to vacate. That if you agreed to vacate by a certain date, the case would remain dismissed. If we have a hearing regarding damages for money, we would have to determine how much the money should be, whether it's $1,000 a month or $1,200 a month.
Or 200.
Excuse me, 200, it'll be $212 a month or 224, whichever figure we use. So he's trying to find a solution short of me ordering a writ of eviction with an amount of money that you can't pay, and it would put an eviction on your record and make you ineligible for other subsidized housing.
Right.
Now, as I mentioned, they have a waiting list. There's people ready and that want this 2-bedroom apartment. I don't think you can presently afford it. Keystone's not helping. Neighborhood Inc. isn't going to help. Whether it's market rent or subsidized we don't know. But that's where we are. So you indicated you were planning to move within 10 days, but right now you don't have anywhere to move to. Is that correct?
We've moved, like our part of our stuff, but we've still got quite a bit to move, But yeah, no, we don't have anywhere to go. Like I said, this whole thing has been a nightmare. But we're devastated.
Yes. So you've already started to move your personal possessions out of there?
We rented a locker and we had moved, part of our stuff, and we had to rent a U-Haul truck, so.
Let me ask this. Can you get everything out of there by the end of March?
Yes.
Mr. Popovits and Mr. Roberts, could we agree on a conditional order of dismissal that the defendant vacate by March 31st? And we can use whatever figure we want. We'll use plaintiff's figure. If they vacate, the matter will be dismissed. Show as a conditional order of dismissal, won't go on their record as an eviction, and would allow them to continue to seek subsidized housing. Mr. Roberts, is that something you could accept?
Well, I'm not sure why I guess if we're going to have a figure in the judgment, then if they pay it, they should be able to stay.
That's true.
And again,
So
without talking to my client, having not had a chance to talk to her in person or really any contact, I'm really reluctant to agree to anything. It seems reasonable. I'm not saying that that's not the case, but I certainly would like the chance to consult with her, concerned that they don't have a place to go, even though they apparently are moving out. Not to throw a monkey wrench into things, but just to maybe clarify some things. The lease that Mr. Popovich attached to his complaint was signed in June of 25. And it was for a year. So it basically, by the time it expired, obviously in June of 20, excuse me, no, it was still in place. I'm sorry, I apologize. The lease had not expired yet. And so they were under the term of a lease at that time. So, but again, I'm reluctant to enter into an agreement without talking to my client, to see if that's something she really agrees to. But if an amount's entered, if we're going to do an amount, then I think, that would mean they'd have a right to redeem if they come up with the money.
All right. Miss Cleveland, I don't think we're going to be able to get there.
Your Honor, how we do this? Meg and I, Miss Bauer and I work well together. She'll resurface. She's appeared to be one of these folks that can probably tell an illness to go away, and it'll go away soon. So I will follow up. I think we've covered absolutely tremendous ground today, and there's some opportunities here to discuss. And if these tenants want to continue to talk to Mr. Roberts or Ms. Bauer off the record about when they can get out, I'm continually open to a conditional dismissal, even if it's not a global resolution, but a conditional that resolves the issue of possession. Because I think if we don't do something that hinders their right to find another complex to move into, we're all better off probably in the foreseeable future. So we could schedule this for a contested trial that would keep everyone's feet to the fire. And I think Ms. Bauer and I can probably work on something else, and then we're not continuing to waste any more of the court's time, if that all makes sense.
You're still with me, right?
Yes, I'm still here.
Okay.
And,
Okay.
you know, you didn't choose to have your power go out today, so that was why it's
No.
difficult. All right, I'm going to continue this matter to next Friday. (3/20/26) at 11 a.m. 11:01, so they can put it in 11 a.m. I'm gonna do an escrow order. You're gonna at least pay March's rent. I don't like this because that's money you could use to go somewhere else, but I'm not gonna keep kicking this can down the road. Right now, you're not paying any rent. Maybe that might be more trouble than it's worth if you're gonna work out a conditional dismissal. Kim, because she doesn't have any power either, wasn't able to tell me what it was she still needed. Kim, were you able to find that?
Yeah, Your Honor, I'm just trying to be able to get enough light from the window to be able to see. Now, I sent them a letter, and they got a letter saying they needed to come into my office. If they would have came into my office, we could have probably gotten everything else that I needed from them, just by them giving me verbal.
All right, what was the date of that letter?
Hold on, let me see if I can, the file's here. I just, like you said, Your Honor, I'm having a hard time seeing things. Hold on. All right. Dan, can you grab me a flashlight by any chance? Hold on. So hard to see everything here. January. Hold on.
Your Honor, can I ask a question? Is next week's hearing?
Well, let her finish this and then I'll let you ask.
Okay.
Can I see it? I don't know if I can see it. Dan, can you go grab me a flashlight? I sent them a letter in November and one in, hold on. I can see the dates, just January. Should be here in the file. Hold on, I just can't see it. It should have went in the packet too that I sent their attorney.
Right, I'm sure.
I sent it on 1/8. They were to come over to my office on that Tuesday at 2 or Friday at 10.
All right, now, Miss Cleveland. Ms. Snow, the manager, says they sent you a letter on January 8th asking you to come into the office to complete the process. She gave you 2 dates to come in January, and you never came in. That's not true. Oh, that's what she contends. And then they filed this action. Uh, All right, Mr. Popovich, you had an additional comment. It's a good thing I blocked out a whole hour because it's probably going to use all of it.
Yeah, I think you've done a tremendous job, Your Honor, trying to flush through this, and I appreciate it. I just was curious, is next week going to be scheduled for the in-person trial or another status conference? And then I wanted, for what it's worth, I certainly appreciate the escrow order option, but I think it only complicates things, quite frankly, because your court is so gracious in that the extensions are only a week at a time. We're not getting into an area where I'd be tremendously concerned. And then when I'm dealing with tenants such as Miss Cleveland, I'd rather her have that money to use to vacate, which solves the problem rather than piecemealing it to the court. So for what it's worth, if we got to somewhere else and there was an argument for continued adjournments or something, then I would certainly be the first to request an escrow order. Here, I think it only complicates things.
All right, Miss Cleveland, I'm going to continue this matter to next Friday, November 20th. Excuse me, November. I don't know where I got that. March 20th.
Right.
At, we'll call it 11 a.m.
Okay.
I wrote 11:01. And we'll call it a status conference rather than a hearing. Now, Miss Snow contends she wrote you a letter in November. She sent you another letter January the 8th saying to come in and complete your recertification. You apparently disagree with that. Do you disagree that she didn't send you a letter or that you can't?
She sent a letter. I went over there and talked to her, and we got into a heated discussion about her telling us that the rent was paid, and then 2 days later giving us a demand for possession. And she never mentioned the letter she wrote asking me to come over there said nothing about a recertification. Just said she wanted to see me in the office.
All right, so we're fleshing it out further. Again, nobody's under oath. So she sent you a letter because she needed more information to complete the recertification. You went over there, got into it with her, and left without completing the recertification. So
she never mentioned the recertification. I didn't know there we had to do anything more for the recertification.
Well, apparently you did. So
no, I didn't.
Well,
I went over there because she just asked me to come over there, said she needed to talk to us. And so I went over there and she never mentioned anything about it.
Well, maybe that's because you got into a fight before you got that far. I don't know. But you never signed a new lease. So they didn't give you a lease that all of a sudden magically reduced your rent to $212. So the recertification was not completed. You never signed a new lease. You haven't paid any rent since November. So you're in a precarious position. And Mr. Popovich is attempting to get a settlement that won't end up with you being evicted. And Mr. Roberts.
I did go through.
Go ahead.
Your Honor, I did go through the proper steps when she told us that our rent was paid, and we never got a late notice in December at all. And on the 12th, she told me our rent was paid. On the 10th, she told Bill it was paid till January 1st, and told us what the subsidy amount was going to be. I called up her management and followed the procedure that they say in the lease to do. I called them 3 times with no return phone call. And then she called and said that they told her to call. Well, the reason I was calling over management was because of the discrepancies with her.
Well, you just didn't like the answer that she gave you. She's getting her instructions. You didn't like the answer that she gave you.
No, what answer?
That you needed to recertify.
No, she never told us. We went over there.
I understand, but you didn't complete it. At any rate, as I said, you're in a precarious position.
Right, right.
And you never signed a new lease. And you may feel that she did you dirty by giving you one figure and then corporate telling you something else. Nonetheless, no rent has been paid. So we're rowing in one direction and you're rowing in the other one. At any rate, we're going to take another crack at this, but next Friday, March 20th at 11 o'clock.
Okay.
I don't want to do this by telephone. This is very awkward, and I understand you lost your power. Kim's here by telephone only. She's sitting there in the dark. So hopefully we won't be in a situation where you don't have power, but if you're concerned about it, you can come right here to the courthouse. In the meantime, Mr. Popovitz is going to be in communication with Ms. Bauer or Mr. Roberts, see if they can get to something. Mr. Roberts, to his credit, isn't willing to just shoot from the hip because he hasn't been availed an opportunity to discuss this with you. So, Mr. Roberts, do you want them to call you this afternoon or simply wait till Meg gets back next week?
I'll call her this afternoon.
All right.
Assuming they have, power or a cell phone, but.
Yes, well, they got this number.
Yeah.
All right. Mr. Roberts will call you this afternoon to discuss this further. Mr. Popovitz, I agree. We made some progress today. We didn't get to the finish line, but we weren't under a time crunch with 10 other people waiting their turn. So I blocked from 11 to 12 to devote to this. All right, we'll revisit it next Friday at 11 o'clock. In the meantime, Mr. Roberts will talk to the clients and the lawyers will continue to work on this. And Kim will have power so she can actually look at her own files. All right, we'll all be in recess. Thank you.
Thank you.
Ms. Cleveland, you're good to go.
Thank you, everyone.
Appreciate everyone's forbearance.
Thank you.
Yes, the fact the lights blinked once or twice here just a minute ago, so we'll go see how windy it is. All right, thank you all.
Take care.
All right, well, that was not fun.
So I got 2 emails from Tyrone Lehman. That's the first one.
At this point, or haven't figured it out.
If I still have a job, I intend to pay the rest of that balance.
Got it. Okay. All right. What I will do is I'll adjourn it out a week, the 20th, March 20th, 2026 at 1 p.m. That's an in-person hearing. What you may want to do is contact Mr. Friedman's office, see if you can work something out, if you see a way to do that. All right?
Thank you, Your Honor.
Thank you, Your Honor. Thank you. Brushwood Properties versus Laquan Morris.
Did you say Daquan Gwinner?
No.
Good morning, Your Honor. David Fantair on behalf of the plaintiff.
Laquan Morris. They are not checked in, sir. If you'd like to take a default, raise your right hand to be sworn. I pick you up on my screen. Do you solemnly swear or affirm testimony you're about to give the truth, whole truth, nothing but the truth, so help you God?
I do. Your Honor, I'm David Fantair. I'm the attorney for Bushwood Properties. And as such, I'm familiar with the books and records as they relate to this tenancy. There's rent owing in this case of $2,380.24. Court cost of $175 for a total of $25.55.24. We'd ask for a judgment for possession with a writ after 10 days if that amount remains unpaid.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested. Writ to issue in 10 days. Mrs. Haverkamp versus Damian Lovelace.
David Fantair on behalf of the plaintiff.
Damian Lovelace. No response. You may proceed.
In this case, there's rent owing in the amount of $2,032. court costs of $175 for a total of $2,207. We'd request a judgment for possession with a writ after 10 days if that amount remains unpaid.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ issue in 10 days. Sandy McFiddish versus, is it Sorso Conley?
Dearsa.
Say it again for me.
Dearsa, Your Honor.
Got it. Okay. All right. What is plaintiff's claim?
The amount of rent, including court costs, is $2,025.
All right. And how is that going to be paid?
I'd like to request an adjournment of 1 week, Your Honor, to consult with an attorney since I've been in and out of the hospital and got the notice late.
We'll adjourn this matter March 20th, 26, excuse me, at 3 p.m. That is an in-person hearing. That'll give you a chance to consult with an attorney.
Your Honor, I just want to clarify. I think Ms. Conley contacted my client about turning in her keys. But it was yesterday and they weren't quite sure how to do that. This is just a possession case, Ms. Conley. So if you're planning on giving up possession, you can turn in the keys at 206 North Huron, and then I would dismiss the case.
Okay.
Just want to clarify, Your Honor.
Okay, thank you. And then Mrs. Haverkamp versus Bradner and 101 South Huron LLC versus Glenn Smith. Those matters are dismissed on plaintiff's motion without prejudice.
Thank you very much, Your Honor. Have a great day. Have a good weekend.
You do the same. Covington Apartments versus True Wind.
Robert Viscounty, P61756 for the plaintiff.
Good morning, Mr. Vicente.
Tenant is.
Yes, Your Honor.
Okay, there you are. Okay. I got a lot of folks on my screen. I just have to find folks. What is the plaintiff's claim in this case?
So, Your Honor, the total inclusive of court costs is $2,393.36.
All right. And ma'am, how are you intending on getting that paid?
So, Your Honor, I just got a new job and it's starting next week, and I need about 2 weeks to get my first paycheck.
To get it paid?
Yes.
Okay. Are you going to be able to pay anything this week?
As of currently, I don't have anything right now. If I have something, I would have paid even 200.
All right, here's what I'll do. I'll adjourn this out to March 20th, 2026 at 12 noon. That's an in-person hearing. If you decide to reach out for SCR or some type of assistance through Hawk, you would have to do that, fill out that form in your packet called the rental assistance form and file it with the court by Wednesday, okay?
Yes, Your Honor, can you repeat that?
Repeat what?
About the Hawk?
About Hawk?
Yes.
Okay, they're an organization that can give you assistance. If you have something to write with, let me give you the phone number.
Oh, yes, I know about that.
You know about it?
Yes.
Okay, give them a call, see if you can get an appointment. But if you do that or you file for state emergency relief, make sure that the form in your packet called the rental assistance form, that you fill that out and get that to the court by Wednesday. Okay?
Yes.
Okay, thank you. We'll see you next week.
See you.
Okay. Peninsular Place versus Daquan Sequina.
Robert Viscounty, plaintiff.
Good winner?
Yes.
All right. All right. What is plaintiff's claim in this case?
Your Honor, the total inclusive of court costs is $3,336.92.
All right. And sir, how are you intending on getting that paid?
I'm actually here right now at the hospital, so I fell behind because I've been in the hospital, I had a stroke, and all my health issues. I actually applied for SER, and I got an appointment with Hawk coming up.
Okay. And do you know when your appointment with Hawk is?
Yes, I can tell you right now. Give me 1 sec. March
Pardon?
19th at 2 p.m. Phone appointment.
Okay. Gotcha. All right, so here's what I'm gonna do. I'm gonna adjourn this out to March 20th, 2026 at 12 noon, okay? I'm gonna permit you to appear via Zoom, okay? All right, so you don't have to come down to the courthouse. You can appear via Zoom, all right? And then we'll see where we are and we'll get some information from Hawk. How's that sound?
Thank you.
You're welcome. Be well, please.
Yep, thank you.
Peninsula Place versus Mohammed Aman. He's here. Mohammed Aman?
Not anymore.
He's not, was he here?
He was. I saw him.
Okay. Then let me pass it.
Your Honor, I can tell you, Mr. Ahmad made a payment this morning.
Yes, sir.
And if that payment clears, we would intend to dismiss prior to the next hearing.
Got it. So maybe we'll let him know if he appears back. I'll just adjourn it out 1 week. 20th, 2026 at noon.
Thank you.
All right. Peninsula Place versus Tyler Robinson.
Good morning, Your Honor.
Good morning, sir. All right, what is plaintiff's claim?
Give me just a moment, Judge. Said Tyler Robinson.
Yeah, TYL.
Yes.
Do you have the case number, Judge?
Yes, 126C 0667.
Thank you. Your Honor, the grand total inclusive of court costs is $910.72.
All right. And sir, how are you intending on getting that paid?
Well, the correct grand total as of yesterday is $835.72, if I'm not mistaken. I made a payment on the 12th of $135.67, and I made a payment on the 11th of $100, which brings my grand total now to, once that goes through, $600 and like some change specifically.
Well, specifically, you also owe court costs. So that's what part of the distinction and the difference is going to be.
And I think probably, Your Honor, the difference here is that the $75 statutory attorney fee was probably not on his account until today.
Yeah, it wasn't.
Okay. So they have a balance of $910. The other stuff comes off. I don't know if you got that, Mr. Vishanti, or not. So how are you intending on getting the rest of this paid, sir?
So I'm outside of the check and go right now to get a payday loan. And I plan to make the $600 payment today, which should close out my case. But again, it just depends on if I get approved or not. So I would request, hopefully, Wednesday of next week.
Okay, try to get it paid by Wednesday. What I'm going to do here is I'm going to adjourn you out to the 20th, 2026 at 12 noon. Okay, that's an in-person hearing. If everything's not paid, you need to come down to the courthouse.
Gotcha.
All right. Thank you.
Quick question. You said the $75 payment. When do I make that, or how do I make that?
You pay that to the landlord.
Okay, so is that like included in, I guess, that payment?
Your total right now, sir, is $910.72. If there was a payment tendered yesterday that hasn't been applied, you'd reduce the balance by that. But what I have right now is $910.72. Certainly, you can go into the office and talk to Holly before you tender your payment.
No, for sure. I'll make the $600 payment by Wednesday. Thank you.
Thank you. Peninsula Place versus Amaria Taylor. Maria Taylor, sit there here. Yeah. I do see. Miss Taylor?
Hi, I'm here. Sorry, it kicked me out.
Well, hold on. Okay, Ms. Taylor, try that again.
Hello? Can you hear me? Sorry.
Yes. Okay. What's your name?
My name is Amaria Taylor.
Okay, you changed it. She's got two. Okay, whatever.
Yeah, it kicked
Okay,
me. Yeah, okay, sorry.
it kicked you out, and then okay,
Yeah.
we do that just to have fun. No, I'm kidding. All right, Mr. Visconti, what is the claim on this case?
Your Honor, inclusive of court costs, the balance is $505.93.
505.93. All right, Ms. Taylor, how are you intending on getting that?
On Wednesday, I went into the office and had a conversation with Holly. My balance was $430, but they hadn't took off the $180 that I paid. And then it would be at $250 after that. And then including the $75 cost of today, I can pay that by Friday next week.
You can pay it by next Friday?
Yes.
All right, so here's what I'm gonna do. Try to get it paid as early as you can. I'm gonna adjourn it out to next Friday, that's March 20th, 2026 at 12 noon. That's an in-person hearing, so you'll need to, if everything's not paid, you need to be down at the courthouse, okay?
Oh, well, I get paid on Friday, but I don't get paid till about 5 o'clock.
Okay.
Sorry.
So what do you do, Mr. Visconti? You want, I mean, I can put it out to the 27th. The balance isn't that high. I don't know if you want me to do.
Your Honor, I'd prefer to just stick with the 20th, and we'll see if maybe we can get a conditional dismissal worked out prior to the next hearing date.
All right, sounds good. All right, so I'm going to leave it set for that time. All right. And they may reach out to you with an agreement to try to have it all wrapped up. But right now, we're going to leave it on the 20th at noon.
Okay.
All right. Thank you.
Thank you.
Peninsula Place versus Brendan Bowe. Present PC. All right. What is plaintiff's claim?
Your Honor, the balance inclusive of court costs is $2,657.42.
All right. And Mr. Bowe, how are you intending on getting that paid?
I was gonna pay $1,000 today. By the 24th, I was gonna pay another $700. I was trying to see if I can do like a payment plan and just I would say by the 23rd, I should have it all paid up.
Okay, so do this. What I'm going to do is I'm going to adjourn you out to March 20th, 2026 at 12 noon. That's an in-person hearing. Get the $1,000 paid. And Mr. Visconti, should they contact your office or should they be contacting your client?
Your Honor, I'd ask that they contact Holly in the office, and then if there are payment plans that are proposed, she'll contact me and she'll
go that way. Okay, just want to make sure.
Yeah.
So Mr. Bowe, pay the $1,000 and then contact I guess Holly. She's a popular person.
She's here.
Contact
she's waving.
Yeah, no, I she's not on my screen right now. I did see her. All right. Contact Holly at the office and see if you guys can work out a payment plan, okay?
Okay, thank you.
Thank you. Peninsula Place versus Darian Fritz. Oh. Darian Fritz?
Hi, Your Honor.
Okay, there you are. All right. And what is plaintiff's claim in this case?
So Your Honor, Mr. Fritz's balance inclusive of court costs is $921.
All right. And sir, how are you intending on getting that paid?
A combined effort of my paycheck and my state tax return. The not the IRS, but the refund tracker said that it's just taking a little bit longer, but that it's approved now and should be here within a few business days. I'm just not sure exactly when.
It's a government, of course, you don't know. So how much are you going to be able to pay?
I was just going to pay it all in full, hopefully within the next week or two.
All right. Well, what I'll do is you contact your rental office, and I'm going to adjourn it out 1 week to the 20th, 2026 at 12 noon. That's an in-person hearing. So if you haven't worked something out, well, even if you have worked something out, I still need you down here. But if you haven't paid it in full by then, you'll need to come down for the in-person hearing. Okay?
Is the 20th a weekday or yeah, it's got to be a weekday. Sorry.
Yeah, it's a weekday. I don't work the weekends.
Yeah. Okay.
All right. Well, I do, but not here.
Yeah.
All right.
Okay.
So it's the 20th. It's next Friday, sir.
All right. Thank you.
Thank you. Peninsula Place versus Kayla Berry.
I'm here.
Eat this double screen. All right. Okay, Mr. Vicente, what is the balance?
The balance inclusive of cost, Your Honor, is $812.
All right. Ms. Berry, how are you intending on getting that paid?
So I actually had made a payment yesterday. I paid the remaining balance on the payment portal. It said $737 and I paid that. So I'm not sure if that's still processing.
So you paid $730 yesterday?
Yes.
Okay. And so let's assume that goes through and you owe $812. When do you think you can get that difference paid?
Most likely by next week.
Okay. If you get it paid sometime before Friday, that would be great.
Yeah.
Get your balance zero, and then they will dismiss the case out because you'll be all paid.
Okay, I just have a question. So for the payment, because I don't see the $812 on the payment portal, is that gonna like pop up the extra that I owe on there?
Yes, there's a $75 statutory attorney fee that my client will add to their ledger today after the hearing.
Okay.
Okay.
Yep.
And that gets you about there. All right.
Yeah.
So here's what I'll do, ma'am. I'll adjourn this out March 20th, 2026 at 12 noon. Okay. If everything's paid, that's an in-person hearing, but if everything's paid, you don't need to come down.
Okay.
Okay. Don't look so happy that you don't come down and see me. That wasn't very nice. No, I'm kidding. All right. But you don't need to come down because they're going to dismiss your case out. Okay. Okay, Ms. Berry.
I do have one more question. I'm sorry. So if I was to pay, let's say next Wednesday or Thursday, I know it takes time for the processing to go through all the way. If it's not processed in time, would I still have to show up?
If they have you at a zero, you don't need to be here.
Okay, and would I just check in with the office?
Yes.
Yeah, why don't you check in there?
Okay.
And then, all right.
All right.
Take care. Peninsula Place versus Tanya Jimerson. Jimerson?
How you doing?
Oh, I'm doing very well. Thank you. All right. What is plaintiff's claim?
So, Your Honor, the balance inclusive of court costs is $1,561.72.
All right. Mr. Jimerson, how are you intending on getting that paid?
So, I already spoken with Zach through Maps, and I got approved for them to pay my remaining balance and my March rent. But the thing about
that was through who? Map?
Yes.
Okay.
Yes. So, because I didn't qualify for Hawk because I made too much, so they agency, and Zach he's just waiting for my call after this court. So they just need an update on my court papers to because the ledger that he got, they added my March rent, but on top of my remaining balance that I owe. But they're willing to pay all of it, and plus my March rent, since I haven't paid on March rent yet. But they just need an update.
Right. They need an updated ledger.
Yes. Yes.
Okay. So I suggest that you go down to the office, get an updated ledger, and get that over to them so that then they know the balance they would need to pay.
Okay, that's fine.
Okay, and let them know, because we've had some cases come through, there needs to be some type of communication sent to the landlord as well as yourself that they intend to pay the balance and exactly how much they are going to pay.
Yes, I talked to Holly yesterday, so she knows.
Holly knows everything, apparently. All right. Okay, so here's what I'm going to do. I'm going to adjourn it out to March 20th, 2026 at 12 noon.
Okay, thank you.
All right. Okay, thank you. Peninsula Place versus Anthony Miller.
Good morning, Your Honor.
Good morning, sir. All right. And what is the claim?
So, Your Honor, the balance inclusive of cost is $1,678.23.
All right. And Mr. Miller, how are you intending on getting that paid?
I paid $240 of what I got paid on Wednesday, and that's processing. I should have everything paid off by the 26th because I get paid the 25th at 1 in the morning.
Okay, so here's what I'm going to do. I'm going to adjourn it out to March 20th, 2026 at 12 noon. And what I'm going to suggest that you do in the interim is contact Holly, see if you can arrange a payment plan or a conditional dismissal, and then we'll go from there. But since it won't be paid by the 20th, you'll need to come down to the courthouse at that time. Okay, sir?
Yes, Your Honor. So when I pay half on the 19th of next week, I still show up?
Yes.
Okay.
Okay, but try to make sure that you're going to work something out with the landlord prior to that point in time. But if everything's not paid, I need to have you down here.
Yes, Your Honor. Okay.
Thank you, sir.
Yeah, thank you.
Peninsula Place versus Anthony, is it Sindendo? There are two S's for a reason. Same thing. Singendo? They are not here. If you'd like to take a default, raise your right hand. I don't think I've had you sworn. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth shall be got?
I do, Your Honor.
Go ahead, sir.
Your Honor, I move the court for entry of a default judgment for possession only. Rent to retain in this case is $584.28. Costs are $177.72. Total redemptive amount $762. Possession only, please, with the writ to issue after the 23rd.
Judgment to the plaintiff by default for possession. Redemption amount in the amount requested with the writ to issue 10 days. Peninsula Place versus Shatoya Cooper. Shatoya, she said she's here.
Yeah.
Shatoya Cooper. Miss Cooper?
She was runner. She's not. She's Motorola C.
I think that's Motorola C, is her.
Amy, I know Miss Cooper was here.
Okay.
Can you hear me?
I can hear you now. What's your name?
Shatoya Cooper.
Okay, she dropped it and then came in. Got it. Okay. All right. What is plaintiff's claim?
Your Honor, inclusive of cost, $949.32 through the month of March.
All right. Ms. Cooper, how are you intending on getting that paid?
I get paid tomorrow, so I was gonna pay it by tomorrow. If the office is
You're gonna pay the whole thing?
Yes, sir.
All right. So here's what I'll do. I'm gonna indicate in my file you're gonna pay the balance by the 14th, 15th. And then I'm going to adjourn this out to March 20th, 2026 at 12 noon. All right. And that's an in-person proceeding. But if you paid everything, I don't need to have you come down. Okay.
Okay.
All right. Thank you.
Thank you.
Peninsula Place versus Elisha Bowe. Or Boye, maybe. I don't know. Oh, he's here.
Sorry about that.
Oh.
Good morning, Your Honor.
Oh, it's okay. What's your name?
Elijah Boy, like a boy with an E.
Okay, like a boy. Got it. Okay. What is plaintiff's claim?
Your Honor, the balance inclusive of the month of March is $2,841.51.
All right. And how are you intending on getting that paid, sir?
I'm able to pay 400 of it today. I'm a full-time student and I had some trouble getting my hours cut a little bit ago, but as of 2 or 3 days ago, I accepted 2 new positions at different jobs where I can work later hours. So ideally, I should be able to start paying that quickly in larger amounts.
Okay. All right. So here's what I'm going to do. I'm going to adjourn your case out to March 20th, 2026 at 12 noon. That's an in-person hearing. So you'll need to come down to the courthouse if you don't have everything paid in full. Got it?
Yes, sir.
Okay. I'm going to suggest that you contact Holly and see if you guys could work out a payment plan. Okay.
Thank you, Your Honor.
Will that work? What are you studying?
Biology. I'm a junior.
Oh, biology?
Yeah.
Why? What do you want to be grow up?
I'd like to be a pediatrician.
Doctor. Okay. You're in a room full of lawyers. All right, never mind. All right. All right, sir. We'll see you next week, buddy.
All right. Thank you, Your Honor.
You're welcome. Peninsula Place versus Ashley Wang.
Wait. Hello.
Where are we? Hello. Oh, there she is. Okay.
Good morning, Your Honor.
All right. Good morning. And what is plaintiff's claim in this case?
Your Honor, through the month of March, the total is $2,064.89, inclusive of court costs.
All right. Ms. Wang, how are you intending on getting that paid?
So my parents need no more help, but they can at the moment until end of March. I was respectfully asking if I can resolve the balance or make a plan, make a payment plan.
Okay, here's what I'm going to do. I'm going to give you an opportunity to talk to Holly and work out a payment plan. So I'm going to adjourn this out to next week, the 20th, 2026, sorry, at 12 noon. Okay. And so I'm going to suggest that you go down to the office, talk to the manager, and see if you can work out a payment plan. If the amount's not paid in the arrearage, you'll still need to show up at that time. Okay.
Okay, perfect. Thank you so much, Your Honor.
Thank you. Have a good weekend.
You as well. Thank you.
Court calls the case, Peninsula Place versus Ariel Fisher. Miss Fisher? Oh, there she is. Okay. And what is the claim in this case?
So, Your Honor, the balance through March is $1,385.23.
I did just pay off $300. Well,
how much?
I just paid $310 on Wednesday, so I don't know if it processed yet. So that stands for my
$310?
Yes, $310.
Do you see that at all, Mr. Visconti, or no?
Give me just a second.
All right. All right. While he looks at that, Ms. Fisher, how are you going to pay off the rest of this? What was your plan?
Going to be asked, can I be placed on a payment plan? But also, out of that balance, 300. Well, actually, let me give you the right amount. $283.34 of that. I had a couple of concerns because I called the office multiple times, but I wasn't given a proper explanation of what I'm being charged for. These charges are coming from a vacant recent charges, and these charges had appeared once my other roommate has moved in. So I was wondering, was I being charged for her moving in? Because also my other roommate was being charged for that as well, and we both.
But are these joint and several leases? Is that the deal, or are these pods?
It's student housing, Judge.
Okay. All right. So it's student housing, but they're not in separate pods. They each have their individual ones. It's a group. It's joint and several.
Right. And we have confirmed that $310.23 was paid, Your Honor.
Okay. Very good. Okay. So here's what I'm going to suggest you do, ma'am. I'm going to adjourn it out to the 20th, 2026 at 12 noon. Okay. What I'm going to suggest you do is go down and talk to Holly. You're going to have to get in line. No, I'm kidding. Go down and talk to Holly, see if you can work out a payment of the other balance, of the remaining balance, and then discuss with her in detail the charges that you have some concerns about.
Okay. Also, when I did go down there like a couple of weeks ago, I don't remember the lady name, but she basically stated to me that they don't do payment plans. Because I asked, can I be placed on one to pay the rest of my balance since I ended up losing my job and I got a new one.
Okay, hold on. Does Holly know anything about that?
Your Honor, we will consider any reasonable payment plan. I'm not going to promise that anything's going to be approved, but if Ms. Fisher has something that she wants to propose, she should convey that to Holly, and Holly and I will talk about it and then let Ms. Fisher know.
Thank you.
Sound good?
Mm-hmm.
Okay. So we'll see you next week at noon. Okay?
That was the 20th?
Pardon?
That was the 20th?
The 20th, yes, ma'am.
Thank you.
Thank you. Peninsula Place versus Jacqueline Gardner.
Hi.
Hello. Oh boy, how are you doing, Miss Gardner?
I'm okay. How are you?
I'm doing wonderful. Thank you for asking.
You're welcome.
All right. What is the claim in this case?
Your Honor, the balance is $4,404.84.
All right. Young lady, how are you going to get this paid?
I was wondering if I could be placed on a payment plan and move out.
Okay, so you want to move out?
Yeah, I don't think I'm going to get caught up in a court timely manner because I lost employment.
Got it. Okay. So when were you planning on moving out?
I can be moved out within a week. If you can give me like 7 days.
So this is a possession only case. So you can certainly arrange to pay the back balance with the landlord. But if you move out by the 20th, they dismiss, and as long as you turn in the keys and give them possession of the premises back.
Correct.
Okay. How do I go about, will it affect my credit? How can I protect my credit?
Well, that may be a more complicated question. But I'd suggest that what you do is if you're going to pay off this back balance, that you talk to them and see if you can arrange some payment plan to get the back balance paid.
Okay.
Okay. So
All
what
right.
I'll do is I'll adjourn it out to the 20th, 2026 at noon. That's an in-person hearing. But if you're moved out by that time and have turned in the keys and they have possession, then they're going to dismiss the case anyway. Okay, Ms. Gardner?
Okay. Will I talk to them or you regarding the same issue with Ariel, the 283? Because I am her roommate and we're both confused on that.
Oh, gotcha. Okay.
Because we're on separate
Yeah, you
leases.
both may want to go down there and talk about that 283.
Okay, because when I went down there, Holly, they were in the middle of transitioning management. They just bought the complex and she wasn't really sure where it was coming from. So I didn't get an answer.
Okay. I think now she is. I think Holly knows everything.
Yeah, we'll look into it.
All right.
Okay, thank you.
All right, Miss Gardner, you take care of yourself.
You too. Do you want to see the baby?
I know. I was going to ask, but I didn't know. Oh, my goodness.
He's almost 1.
No, he's not. Is he really?
Yeah, come May.
Oh, man. Look at that. What? You know what? I should actually make you come down whether you move out or not to bring the baby. But I won't do that. I see you. All right. Thank you. Good luck to
Thank
the two of
you.
All right.
Thank you.
Peninsula Place versus Fatima. Is it Diwa?
Yeah, I'm here.
Okay. I mispronounced your last name, didn't I?
Everybody does. It's Diao, but it's fine.
Yeah. Okay.
Yes.
All right. I'll try to remember. All right. What is the claim?
So, Your Honor, the balance through March is $1,745.93.
All right. All right, young lady, how are you going to get that paid?
So I just got employment, and with the help of my father, we're trying to pay half of the balance by next week and the other half by the end of the month.
God, I see what you're saying. Okay, so here's what I'll do. I'll adjourn it out 1 week. March 20th, 2026 at noon. Okay, that's an in-person proceeding, and you'll have to appear at the courthouse. What I suggest, if you're going to be able to work something out, that you go in and talk with Holly or talk with the manager there and make sure, well, she is the manager, but anyway, make sure, talk to her and see if you can work something out regarding that payment schedule. Okay?
Okay. All right. Thank you.
Thank you. Peninsula Place versus Shayla Taylor.
Good morning, Your Honor.
Good morning. How are you?
I'm good. How are you? Sorry about that.
Okay. Why was she screaming? I don't know.
Technical difficulties.
Oh, okay. All right. That's fine. All right. What is the claim, Mr. Piscani?
So, Your Honor, we show a balance of $686.74 through March.
Gotcha. I just made a payment.
Okay. How much did you make?
I brought my balance to zero, but when I went on there, it said 611 this morning at like 8 a.m. So they could have added that $75, but
yeah, it'll show up today.
Okay, yeah, I paid it to zero, but then the 75 is probably on there, so I can get the 75 paid probably today. But does that count, or is it like is that a part of the rent, or is that just like the extra charges?
That's part of the court cost.
Okay.
All right. But if that doesn't get paid, then it's put on your rental bill.
Gotcha. I will pay that.
You got that?
Yes.
Are you a student?
No, not right now.
Not right now? Okay.
Nope. I'm just working.
Just working. Okay. All right. I'll adjourn this to March 20th, 2026 at 12 noon. If you have that all paid and everything is paid to zero, I don't need you to come down to the courthouse. But if it's not paid to zero and you still owe something, you'll need to appear in person. Okay?
Okay. Thank you.
All right. Thank you. You have a great weekend.
You too. Thank you so much. Bye-bye.
Peninsula Place versus Michael Pugh. Oh, yep, there he is. All right. What is the claim in this case?
Your Honor, the balance is $3,656.03 through the month of March.
All right. Mr. Pugh, how are you intending on getting that paid?
Oh, yesterday I had paid $600, and then Tuesday I applied for state emergency relief. They're still processing my documents. So until I hear something back from them, I could pay another $350.
Got it. Okay. So have you applied through Hawk for any assistance?
No.
All right. I'm going to suggest that you call them and apply for assistance, because how many people are in your unit?
It's 3, but it's like individual rent, not
separate leases.
Yeah. Okay. So just so that you know, if it's just your lease, your state emergency relief, if they pay it, is only going to give you about $410. Okay. So you got something right? You got something to write with, or something to take down a phone number?
Yeah.
Okay. It's 734-961-1999. That's housing access for Washtenaw County. I'm going to suggest that you talk to them and see about if there's assistance out there that can help you pay down this balance, okay?
Okay.
All right. And if you do, but if you've applied for SER, you have a tracking number. And if you apply through Hawk, there's a form that came in your packet called a rental assistance form. You'll need to fill that out and submit that to the court by Wednesday.
Okay.
Okay?
Okay, sounds good.
All right, I'm going to adjourn this to March 20th, 2026 at 12 noon.
And is this in person or?
Yes, that is in person, sir.
Okay.
Okay?
Yeah.
Thank you. Court calls the case of Peninsula Place versus Sanders. Hey, she's not checked in. And I mispronounced her first name. I can't say that. She is not here. You've previously been sworn. You may proceed.
Thank you, Judge. I'd move the court for entry of a default judgment for possession. Rent to retain in this case is $5,523.34. Court costs are $177.72 for a grand total of $5,701.06. Judgment for possession only, please, with the writ to issue in 10 days.
Judgment to the point. That's by default for possession, redemption amount, any amount requested. Writ to issue in 10 days. Peninsula Place versus Xavier Townsend. Here. Xavier Townsend? Oh, there you are. Okay. What is the claim in this case?
Your Honor, the claim in this matter is $3,954.23, inclusive of court costs.
All right, Mr. Townsend, how are you going to get that paid, sir? We have Mr. Townsend? If you're speaking to us, I can't hear you. Pardon? Yeah.
You know?
Now, yeah, if you turn off your earbuds, that might work.
Yeah, I had to.
Josie, come over here. This microphone is more awesome.
Yeah, I had to turn them off.
Okay.
Yes,
all right, sir.
Yes, sir.
How are you intending on getting this amount paid?
Yes, I was planning on paying off about $300 today, and I was planning on talking to Holly about a payment plan. I had called multiple. I had called twice. I had called before like a month ago. I didn't get an answer, and then I called at the end of the month, and I got I was finally able to speak through one of the secretaries or staff members there, and I was told that they didn't do payment plans, so I would have to wait to speak to you about it. And I was hoping to potentially talk to Holly about getting on a payment plan, possibly paying about $900 for my next couple of checks, about $900 for my job.
Okay, here's what we'll do. I'll adjourn you out to March 20th, 2026 at 12 noon. That's an in-person proceeding. I'll give you that week to go down.
Pony Club. I'm gonna keep on dancing at the Pink Pony Club. I'm gonna keep on dancing at the West Ponywood. I'm gonna keep on dancing in the world.
Speak with Holly, see if you guys can work out a payment plan or some other type of agreement. If the balance is not paid, you'll still need to come down to the court. Okay?
Okay, sir. And also, I was planning going through my job for like a possible grant, also for about $2,000. And when I file for that, if they approve it, I'll be able to use that also.
Gotcha. Okay. So you got a plan, and it sounds like you got a plan. Just got to wait for the pieces to fill in.
Yes, sir.
All right. Talk to Holly. We'll see you next week.
All right. Thank you. I'll see you next week.
Thank you.
All right. Goodbye.
Court calls the case Peninsula Place versus Taylor Singleton.
Good morning.
There you are. Hello, Miss Singleton.
Hello.
All right. What's the claim?
So, Your Honor, the balance is $751.02 through the month of March.
All right. And Miss Singleton, how are you going to get that paid?
So here's the case. So prior to this situation, and I know you probably heard that the the property was sold to new management. So prior to this, I was experiencing charges on my account regarding the VCR charge, and in the leasing agreement on page 21, it states that $50 will be credited or added to the resident's account if DTE is not set up in their name. And for my case, me and my roommate were paying for service in another unit when moving in. So we were being charged. So basically it's an A side and a B side, and we lived on B side, but we were paying for utilities on A side. So it was reflecting as if we hadn't set up DTE. Given that, once we caught that in November, I moved in August. So in November, we transferred over the service transfer over the utilities to our service unit, and all of the charges were then transferred to my unit. So it basically took some time to credit my account for the recent charges, and then the property got sold, and then our account was never settled. Given that we're in new management, they're like still working on those charges. And I did go to Holly when she first moved in to her position, basically speaking with her about those charges. And she informed me to reach out to Zigo, who was billing our account. Now, when I reached out to Zigo, they basically said, well, you were with American Campus Community, so you will have to reach out to them because you didn't have a direct account through us. We were just billing you through them. So then I reached out to American Campus Communities, and they basically said, well, since the property has been sold, it is up to the new property management to credit the account. Yeah, here we are.
I got you.
I'm just making sure because this is the longest case probably. Y'all just been moving on.
But no, you were telling a great story, so I was going to let you go.
Basically I contacted American Campus Communities. They said that it would have to be settled through the new property management. And just yesterday, I spoke with Holly because I had went in to print out some papers, and she basically informed me that they have to go into the other unit in which we were paying for and credit those charges to them and then settle our account afterwards. So it was really just a waiting game. And then in addition to that, speaking with Holly, she even said that she gave me a ledger about 2 weeks ago to see kind of the charges on my account, and began to follow up with me about that. And it was basically saying that I did have some late fees, that some of my charges did roll over into following months. So let's say, for instance, if I had a payment of $700, but my charge was $729 for a specific month, and that rolled over into the next month. Now, while that may be true, on our leasing agreement, it says that if a balance is over $100, then it will be subject to late fees. So if I had a balance that's $13 rolling over into the next month, or anything under $100, I wouldn't be subject to late fees. So I am basically implying that
Taylor.
Yeah.
All right, take a breath. All right, because I get what you're saying. Here's the only problem. I don't have any paperwork in front of me to be able to even follow the numbers that you're giving.
Okay.
You got it? Okay. So here's what I'm going to do. I'm going to encourage you to go in and talk to Holly again. Okay. Just to see where everything's at. See if you guys can resolve it. I'm going to adjourn this to March 20th, 2026 at 12 noon. That's an in-person hearing. Okay. So then you can come down there, and if you haven't worked it out, then you can explain all of that to me. Okay.
One more thing before I go, because I'm actually a student and I have Friday classes, and I already missed this Friday to attend this meeting, and then I'll have to miss next Friday to attend another court appearance. So I just attended just because it said if I didn't, I may be like subject to eviction or something like that. And I just
Okay, hold on, just slow down. Go in and talk to Holly, and if you can't do that, what time is your class?
it's from 9 to 12.
9 to 12? Okay, so I've set this at 12. You're at Eastern?
No, I'm at University of Michigan.
University of Michigan?
Yes.
That's why you talk so much. All right, no, I'm kidding. What are you studying to be?
I'm getting my master's in public health.
Okay, fantastic. All right, so we'll make a note. I've set it at noon, right? Finish your class, get yourself down here. We won't do anything till you get yourself down here, okay? If you do that reasonably. That way you don't have to miss class.
Okay.
Fair enough?
Yeah. And then will I just bring all of these documents to the next meeting and then this will be set?
Bring everything you have so that I can take a look at it.
Okay.
Okay. All right, but make sure to go down and talk to Holly, see if you guys can work it out yourselves, okay?
All righty.
All right, thank you, ma'am. Court does call the case. Peninsula Place versus Landon Brooks.
Easier.
Landon Brooks?
Hey,
Oh,
hello.
there he is. Hello. All right, what is his claim?
So, Your Honor, the balance is $4,125.78 through the month of March.
All right. Mr. Brooks, how are you going to get that paid?
I had lost my job, but I just currently got one, and I could pay $1,000 today, and I did apply for the SER, and I also could pay like $600 next week and continuously pay $600 every week afterwards.
All right. So you're going to pay $1,000 today, right?
Correct.
Okay. I'm going to adjourn this out to March 20th, 2026 at noon. Did you call Hawk at all or no?
No.
All right. You got something to take a phone number down?
Yeah, give me 1 second. All right, I'm ready now.
Okay, 734-961-1999.
Okay.
Talk to them and see. You got to be under 3,000 if they can assist you, but it looks like you can get there and see what they can possibly assist you with. The other thing that you need to do is in your packet, there's a form, a rental assistance form. You'll need to fill that out, put your SER tracking number on it, and file it with the court by Wednesday.
Okay.
Okay?
Okay, and you said I got another court appearance next Friday at 12?
Yes.
Okay.
Next Friday at 12. That's it in person. So you'll need to come down to the courthouse, okay?
Okay. Okay, thank you.
Thank you. Peninsula Place versus Amy Dagny.
Yes, I'm here.
Okay, hello. And what is
Hello.
plaintiff's claim?
So, Your Honor, the balance here is $1,681.12 through the month of March.
All right. Ma'am, how are you intending on getting that paid?
So I will be getting paid this Wednesday, so I'll be able to pay the $700, and then I'll just reach out to my mom for the rest.
You'll just be, I'm sorry?
So I'll be able to pay $700 this Wednesday, and then
Yes,
for the
ma'am.
rest, I'll just reach out to my mom to help.
Got it. Okay.
Mhm.
So 700 by the 18th. I'll adjourn this over to March 20th, 2026 at 12 noon. All right. If you have everything paid by that point, I don't need you to come down. That's an in-person hearing. If you don't have it paid, you'll need to come down to the courthouse, see what we can do. Okay.
All right, thank you.
Thank you.
Bye-bye.
Bye-bye. Peninsula Place versus, is it Yaye Sisi?
Yes, I'm here. Hello.
Hello.
Yes. Hi.
All
How are
right.
you doing
Did
today, Your Honor?
I'm doing wonderful. Thank you for asking.
Yeah, no problem.
All right. And what is the claim in this case?
Your Honor, the balance through March is $1,799.43.
Say that again. I'm so sorry.
$1,799.43.
Okay. Thank you.
Okay. And how are you going to get that paid?
So next week, Wednesday, I'm planning on paying 900, and then the remainder I was gonna speak with Holly so we can set up a payment plan where I can pay at least 90 of the rest by the end of the month.
Got it. Okay. So what I'll do is pay that 900 by Wednesday. I'll adjourn this out to the 20th, 2026 at 12 noon. That's an in-person. She's still there.
Yeah, I'm still here.
Okay. So that's it. That's an in-person proceeding. So you'll need to come down to the courthouse and I will give you a chance to talk to Holly and see if you can work something out. Okay.
Okay. Thank you so much.
Thank you. We'll see you.
Okay. Bye-bye.
Peninsula Place versus Maya Manning. Nope.
Good morning.
Hello, Miss Manning. There you go. She got the technical things worked out. All right. What is plaintiff's claim?
Your Honor, the balance through March is $2,846.19.
All right. Miss Manning, how are you going to get that paid?
So I had a work study and a job. So my work study check went to rent and my job went to my car because I'm financing it. So, but I don't have my work study no more, so I only have one job. So like the most I would be able to pay will be $500 on the 18th, but I am moving out at the end of this month. Well,
So you're going to pay $500, but you're trying to move out by the end of this month.
I am moving out at the end of this month.
Okay. So what I'd suggest you do is, if you're going to move out, this is a possession case. So they're just looking for possession of the apartment. Okay.
Yes,
so
Your
you
Honor.
might want to work out some arrangement in terms of the balance and everything. You pay the $500 and then work out how you're going to get that paid, and then work out some agreement so that it's just a move out. And if you move out, then the matter can be dismissed if you keep with your payment plans, or something along those lines. So what I'm going to suggest you do is I'm going to adjourn this out to the 20th, 2026 at 12 noon. I don't know why I can't remember. At 12 noon. And what I'd suggest you do is go in and talk with Holly and make sure that you're clear on the move out procedure, such as turning in your keys and the like. Okay.
Yes, Your Honor.
All right. Thank you. We'll see you next week.
All right. See you.
Peninsula Place versus, is it Hangama? Is it Safiri? Yeah.
Yes.
What? All right. Hello.
Yes.
All right. There you are. Okay. What is the claim in this case?
Your Honor, the balance on this account is $759.10 through the month of March.
All right. And how are you intending on getting that paid?
I request